Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
Is that correct?
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Literally not true.
I didn't ask you to interrupt me.
Prosecutor.
Dahil mihi Anglican police, verbal slaughter. Oh, for crumb's sake.
Good morning, good morning, good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Good to have you all here. Welcome, welcome, welcome one and all. Let's see, we've got, hey, that's fun. I guess I've been stripped of my courtroom. Well, at least I'm here. That's pretty cool. I'm not in the box. They let me out of the box. I guess I can just like show up in court and, you know, let's see, I can be like here. I can just be like, hey. That's pretty cool. All right. Snazzy red shirt. Ah, yes, I deviated from my usual purchase and got a red one. Good morning, good morning, good morning. Oh my goodness. I like it without the court behind you. I sort of like it myself. I feel liberated. I feel like I can just I can do whatever. Reserve your box seat. I've been rehomed. My home has been rehomed. Someone is probably sitting in my courtroom right now in my seat. And I don't know. I don't know where they are. Good morning. Good to have you here. Welcome, welcome. Happy. Oh. You know what's coming. If I don't want any class action lawsuits, I don't want any complaints, I don't want any that scared my cats, nothing. You guys know.
Mike. What day is it, Mike? Guess what today is?
It's Hump Day.
Hump Day! Welcome to Wednesday. Woo! I used all the air that time. It's when 2 thumbs up. 2 thumbs up. It's Hump Day. We made it halfway through the work week. Your throat is going to be sore. I have water. What? My wife just shows up. She's like, you need some of this right now. Yes, we need some water. It is Wednesday. Sounds like one of those weather alerts. Did RA go lightheaded from that yell? Yes, I did. Sloth Life, first in chat. Congratulations, Sloth Life. Thank you for being here promptly and getting everything going for us in chat. Because of your diligence and hard work, we're going to punish you. That's right. We're going to send it to internet ownership. You're responsible for everything IP-related worldwide until we go live again. Where was your son? I bet you would have got a thumbs up. I got 2. I got from my youngest son and from the middle son. I got thumbs up. Well, there went 2,000 more subscribers, and now RA can't sing, so sorry if you have a birthday today. No, that was a warm-up. That was well within my range, my dynamic range. So, Kasky says, I'll smash the like for that. You have a low bar, Kasky, but thank you. We appreciate it. All right, today was not the day to wear headphones. I'm telling you, I warned you. I looked frozen there for about 7 seconds. Thought I might pass out right there at the end, but I survived. Maybe we need a merch item that says I survived the Hump Day yell. I'm not sure if that would go over well or not. Maybe a shirt, maybe a badge, maybe some sort of a commemorative coin. You need to clip that one and just reuse it every week. Yeah, Screams with Sam. Speaking of Screams with Sam, it's Hump Day. Yes, it is. It is Hump Day. Screams with Sam. Thank you very much. 20 months, an OG amongst us. Thank you. Love your profile picture, by the way. The headphones with the ears are something I've never had the nerve to try to pull off, but the people who do it well, as you do in that picture. I took my earbud out, and my daughter was like, "What was that?" So, that was Hump Day. You need to go on America's Got Talent with that one. That's the problem is you have to have something, should you make, maybe this is a little presumptuous of me, but I think I'd make it through round one, right? I think I could do that. Round two would just be like, well, it better be a Wednesday because I ain't got nothing but that. Yeah, I would buy it, says Tisha. I survived Hump Day would suffice. That would be good. Kimar says, that was the best in my 2 years. She's been keeping track. That is wonderful. All right. Can't wait for the Irrelevant podcast tomorrow. Yes, I'm so excited. I miss hanging out with Thomas and y'all together, which is good. Let's see. We've got a couple things to do before we start jumping around courts, and lots to talk about. The world of true crime is active right now. In spite of the fact that we're not actively following a big case that's currently being tried. But there is a lot going on, lots of things to talk about. And man, crime is at an all-time high. So that's good news for futures in the true crime world. So yeah, there's plenty of things happening. I mean, dare I ask, I saw the headline, what is up with the skin-covered bear, the human skin-covered teddy bear in California? Do I want to know? Is that something we should follow? Is that something we just wish we didn't hear about? Yeah, we've got some questions. Anyway, Detective Vid says, Recovery Addict, did you see the grand juror being charged in the Karen Reed hit? There's another thing. Yes, a grand juror charged in the Karen Reed case. This is somebody who sat on the grand jury and got her indicted in this. Charged with telling somebody what was going on and who was going on, what they were saying. Terrible. Tower Hill Girl, wow, member for 28 months. Thank you very much, Tower Hill Girl. Have you heard about Sarah Boone's new letter? She's not happy with her appellate lawyer. I can tell you that. She put that in the letter. Lots going on there. I mute it until I see your mouth closed. Deanne, you can't go wrong there. That is a sound strategy. I do not blame you. As a matter of fact, other people should probably follow suit. Let's see. I'll be driving to the lake. Going to miss the podcast, sadly. Oh, Tisha, just for you, we're going to save this copy, and it'll be available on replay afterwards. Just this one. Just let us know when you've listened so we can delete it. No, just kidding. We save them all. You can catch it on replay. Sloth says, so say what? Say what? Yeah, gross. I'm just telling you, as we follow the headlines in the world of true crime, I like to keep an eye on what's coming up, which basically means what did the police do yesterday? Okay, that's basically how far out I look. I have not found an effective way to look beyond that into what crimes are about to be committed. Because honestly, I think if I did find that, I'm pretty sure I could be charged with something. So this is as far as I can go. What did the police do yesterday? And sometimes today. Didn't want to know about the bear. Yeah. There we go. We have some birthdays to celebrate. Let's do that before we go too far and talk about crazy stuff, which we will do for sure. The skin-covered bear was a prank. Someone sells them on Etsy. The kid got arrested for it, apparently. Silly Claus, I have questions. Prank, I'm like, oh, good. Sells them on Etsy, I'm thinking, sick. And then kid got arrested for it. How can you get arrested unless it's, like, real? And there, at that point, it crosses the line from prank. That's oh man. Okay, now I'm Let's. On that note, everyone, we're going to sing "Happy Birthday." Everyone, stand up, take a deep breath, shoulders back, project your voice to the bathroom, to the back of the room, or to the bathroom, whichever you prefer. Blend your voice with your neighbors. Warm up with me, if you will. La 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 la. See, I still got it. Still got it. It's good. We're going to sing to Dustin and Tower Hill Girl, celebrating their birthdays today. Happy birthday to you. Happy birthday to you. Happy birthday to Dustin and Tower Hill Girl. Happy birthday to you. There you go. Uh-oh, there's another buffer. Kelly King, we're going to add to the list. So, Kelly, you get the next verse here. All for yourself. Happy birthday to you. Happy birthday to you. Happy birthday, dear Kelly King. Happy birthday to you. Dustin, Kelly King, Tower Hill Girl, all who are celebrating the birthday today. Happy birthday. I realize there are a million places you could be, a million people you could have celebrated with, but you chose to be here with us. The privilege, pleasure, the honor, the joy is ours. Hopefully we can turn some of that joy back to you, make your day a little more special. Begin by helping yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's, Tammy Dunlap's House, Andy's Grill, Bob Evans, and Cracker Barrel. Uh-oh. Happy birthday to you. There's another one. Trent just slipped in. Happy birthday to you. Happy birthday, dear Trent. Free pancakes, too. Happy birthday to you. Trent, all the same birthday wishes apply to you. The pancakes, the well wishes, the joy, all of it. Specialer, everything. Happy birthday. Slid just in under the radar. I'm not sure how you did that, actually. That was like last minute. It's like hitting the garage door and then running and sliding and just right before it closes. You know the ones that didn't have the sensors, the ones where they can really squish it. Okay, drum solo to finish. Left hand is a snare, right is the cymbal. Beautiful. Great job. Happy birthday to all who are celebrating. It's wonderful to have you here. On that note, let's see. You all see Cracker Barrel is moving away from selling so much stuff and remodeling the restaurants to add booths and white walls. Crazy stuff. They tell you, restaurants are having to sort of reinvent themselves. The same thing we've done all along is not working anymore. So. As long as they keep selling great pancakes and chicken fried steak, I think they'll be fine. All right. Love Cracker Barrel stores. I just like playing checkers on a barrel outside while I wait for my food. That's just what I like. All right. How was your day? How was yesterday? What did you like? What did you not like? We have a few things. The fried apples. Oh, I've not done the fried apples. I just can't. I cannot bring myself. I can do fresh apples. I can do dehydrated apples, but I cannot do fried apples. What was the outcome of the situation in Tennessee yesterday? That's a great question. Does somebody have the answer for me? Because I do not know. I know that the radios basically went silent, and we're just waiting for an answer. Ended peacefully. Oh, that's the best possible scenario. At 6 p.m. Okay, so it took a while, and then he gave himself up. Let's see. Josh has what Josh does best, and he has a suggestion here in chat. Let's see. Chats. Mod chat. Oh. Somehow I'm in my local town utilities chat. I'm like, what is this? There is a there is a case. Josh says this was Samantha, not me. Samantha found this one. Thank you, Samantha. Thank you. This is there is a case where a defendant pled guilty, but now has a sentencing phase. So it would be interesting. In this case, because he pled guilty, there was no trial, and the facts of the case still have to be considered for the sentencing. And so we would hear basically 2 weeks of trial, but the only possible outcome or the only thing to be decided is how long he will serve as a penalty. That's the Florida versus Shelby Neely. This is a crazy case. I believe, if I understand this one right, this is Shelby was the husband who killed his wife, and then tell me if this is the right one, Samantha. Killed his wife, then pretended to be her in text messages to the in-laws, who were out of the area, maybe even out of the country, and then they got suspicious and wanted to come see what was up. After he's posting pictures of their child and everything else, and answering like he's her, and then they show up, and he kills them too. You can't make this stuff up. Is that the right case? Am I thinking of the right one? It's wild. It's wild. Florida's full of crazy cases. Stearns' case is next. I know that's I don't think Stearns is the one it's not good for this channel, right? Media circus at work today. Mark Zuckerberg in the house. Yeah, that's a media circus for sure. Let's watch him get sentenced. I like that part of the trial the best, says Virginia Little. That is psycho. Basically, we would hear the facts of the case like they were proving his guilt, but they're only proving the guilt for the purpose of sentencing. Like, this is what he did. So it would be, we'd basically all be united on whether he's guilty or not, because he pled guilty already. Cheryl B., the trip was fantastic. It took longer than I expected to recover. It was more grueling than I expected, and I did expect it to be tough. But it was, let's see. I think it was great. It was a great trip. Let me do this. We had a doctor on staff for this trip because it's the sort of trip that you want to make sure everyone's nice and safe for, right? Let's see. I asked him to summarize this little trek we went on, to summarize the injuries. I'm not going to show you the video, or I'm just letting you hear the audio. The injuries that we had, and this is with 98 teenagers and about 13 times 2, 26 plus about 40 adults, support staff. Ready?
So we had a total of 4 priesthood blessings by newly ordained elders, innumerable amount of blisters, 4 sprained ankles, 2 sprained wrists, 1 sprained knee, 1 thumb contusion, 11 lacerations, 1 concussion, 7 cases of dehydration, and 1 case of heat exhaustion. We used a total of 4 rolls of Leukotape, 54 sheets of moleskin, 37 Band-Aids, 7 ACE wraps, 61 ibuprofen, 17 Tylenol, 2 alcohol wipes, 27 Vaseline packets, and several hundred electrolyte packets on this trek, but there were no ambulances needed and no hospitalizations.
Okay, so that just gives you a slight indication of what the doctor was doing all week long. And I admit that 2 of those ibuprofen he counted were for me. 2 were for me. How much was that for just the ibuprofen? I did not need only 2. This surprised me. Only 2 alcohol wipes. We're literally sleeping in a field that we had to chase the cows out of, and only 2 alcohol wipes. That is just crazy. All right. Anyway, how many ibuprofens? I think 61, I think. That's not bad. That's not bad. Basically, every adult took at least one. That's what happened. Yeah, lots, woefully short on wipes. I don't know what they did to clean wounds, because we used fewer alcohol wipes than we had wounds. The cows didn't want to snuggle. The cows got very interested when I was flying my drone. Like I went up to a hilltop and they were up there and they were all just eating, and I was quiet because I showed up on my e-bike, and it's just like it just rolls right up, and they see me and they all turn around to face me, and they stop moving and they stop chewing. Now that's the part that gets me. Cows, when they're chewing, it's like, hey, everything's good. When they stop chewing, I don't know what they're thinking. I'm not thinking, are they like, if we charge in unison, you can't get away? I have no idea. But flew the drone and they just watched me. And then when I came in and landed, and I might have flown a little close to them, they all ran. But cows are great. They're great. There's no chat on my TV. Help. Oh, no. Jade. Don't think you use alcohol wipes to clean the wound. That would hurt. I don't know what they used them for. Perhaps they spit on a Kleenex and wiped the dirt away from the wound. I think that's what it was. All right. Anyway, we had a blast. Cows run, not willingly. Anyway, it was great to have the doctor there. He was constantly, the radio chatter, constantly being called on the radio. Speaking of which, okay, can you find it? Did you just take it? Okay. Kids are doing projects and we need pictures from inside the attic. All right. With that said, we've got a couple things we're waiting for. We're waiting for Judge McNally to come back because he's currently not. We're also waiting for Judge Simpson to come back because he is currently not. And this is weird. I'm like in front of her. I feel like I'm like Mystery Science Theater is what this is, but I'm facing you. I think that's what it is. It's wild. No anniversaries today. I don't know of any. I haven't seen any in chat. Let's see. We could read the Sarah Boone letter. See if I can pull that up really quickly. That's one we have not read. I know it's a week or two older. Sarah Boone letters. Okay. Trying to remember. I can't even remember what county she's in. Is it Orange County? Thank you. If you guys want on the PVC, you might be able to get one that has the bell end on one side, which doesn't require the couplings. Okay. All right. Do we get sad piano music? If I can find the letter here, just one second. Orange County. Okay. Take a quick look. We have not been in let's see, case records, first name Sarah, last name Boone. Somebody's calling. Hang on one second. Hello?
Yes, hi. This is Logan. Are you the ones that have that I'm renting?
Hang on just one second. How did my renter get my burner phone number? Okay, that's my Airbnb renter. Now you know, Logan. Hey, Logan, how's it going? That was he gave us the figure. I did. Let's see. So she might be here. Logan, how are you doing? How's the Airbnb? Let me know if there are any problems. How do I rent the Airbnb? Alyssa, basically you become a traveling nurse, and then you work through their scheduling programmer, because we've taken it off Airbnb. Airbnb has just been nothing but problems for us as far as, and it's not the renters. It's not the Airbnb renters. It's Airbnb itself that we've jumped through all the hoops they have us jump through, and then at the end of the day, they're making it just impossible even to collect our money, and now they're wanting all sorts of information from people. We've got investors that are currently in the Arctic Circle, and they're like, we can't proceed without them online doing this. And I'm like, are you kidding? Our business partner is in the Arctic Circle right now, like literally the furthest north town in Alaska. And as a traveling nurse, that's what she's doing. So, yeah, we're done with Airbnb. So that's the way. Become a traveling nurse and get assigned to somewhere in North Carolina. Maori prison, that's an option. They take traveling nurses. Is Santa investing in it? You got us. You got us, MJ. No, we've got the wife of my friend who's a contractor is a traveling nurse, and she's currently in the Arctic Circle in Alaska. Let's see. I think it's the Arctic Circle. It's the furthest north town, whatever that is, Nome or something. I've heard Verbo is better. Honestly, the problem we have with Airbnb, I know I'm on a side note here, but the problem I have with Airbnb is that they're very short-term rentals, usually like 3 days to a week long, and they get booked way in advance, and then we have somebody who comes to us and says, I'd like to book it for the next 6 months. We're like, oh, we could, but there's these 3 days in July that you're going to have to move back out and then move back in. It would be much better for us to just have just continuous coverage, because a lot of people just don't want to do that. They move out and move back in. Are you going to follow the Green Beret killer out of Fayetteville, North Carolina? Has he been caught? Kate? I don't know that one. I would like to. Fayetteville's a little far east for me to arrive, like to be at the courthouse. That's a bit of a trip that way. But Fayetteville is a beautiful, beautiful part of the state. Let's see. The woman killed her Green Beret husband. Wow. I thought they were invincible. The Green Beret, the one with the Tesla. Did this just barely happen, Ginger Snaps? Sorry, while I'm doing this, I've got to download Sarah Boone's letter. Not a robot. Search. I've not done the search in so long. State of Florida. It is on appeal. Notice of inquiry. Order. Appeal trial transcripts. Holy cow. There is a file that was posted to the docket in April. The appeal trial transcripts, 2,529 pages long. You can just click on it and get it. Wow. She killed him, cut him up, and dumped him in a pond because he wanted a divorce. That's like one of those bad genies where it's like your wish turns into, it's like the monkey paw story. Is it notice of inquiry? This is it. I got it. Okay. We're good. I found it. It's a little different than a regular letter for a couple reasons. Mostly because it's typed. And we didn't know that she had access to a computer. I guess now she does. This was filed on the 8th of July, so about 8 days ago, about a week ago. Let's do a quick review of what she's complaining about. It should be quick because we can read it quickly. We might play some sad music if it becomes appropriate, but we have to wait and see what the letter's about. She might just, this might be just normal. Name is Shanna Cloud. A few of the mods want to check it out. KK, so when did this just happen? I mean, was it in the news or is it in trial? Is the trial scheduled for this Fayetteville trial? Sloth Life, I missed all of them. I've been distracted, but I will go back. I promise. Right now, I will. Right before we jump to Sarah Boone's letter. Candace Hoff, 15 whole months of gifted membership. Blessings, Candace. That is wonderful. You are a gift-getting receiver, which is wonderful. I love it. Thank you. Thank you. Lacey Spano, member for 21 months, another OG. So thankful for 21 months with you all. I love you guys so incredibly much and the family we have. And then, of course, we've got the Purple Hearts, which I think is, a tribute to Emily D. Baker, which is great. Screams with Sam, member for 20 months, says it's Hump Day. Thank you, Screams with Sam. Appreciate that. Kim R. Hey, what's up?
Can we fill this outside 1-inch bowl?
Yes. You'll need a new one. That one's garbage. Expanding foam. Kim R, that was my best 2 years. Thank you, Detective Vids. Member for 14 months. Recovery Addict, did you see the grand jury being charged in the Karen Reed case? We did. Tower Hill Girl, member for 28 months. Just wow. Just wow. That's all we got. Just wow. And Kelly H. gifted a membership, kicking things off in style. Thank you for your generosity, and congratulations to all the OGs and for the great support. Let's see if we can. What does it look like if I'm just in front of the page, just floating? Well, like that. All right. So let's take a peek here at this letter. Comes now, Sarah Boone, appellant, and respectfully. Where's my mouse for this one? Is it this one? Why is the mouse not working? It's because I turned it off. The mouse has to be turned on to work. I just found this out. I respectfully move this honorable court to please provide status of our court-appointed appellate attorney Joshua E. Adams, Esquire. Help me find my lawyer, please. In addition to our inquiry to the status for pending appeal. I want to know what the status of my lawyer is and the status of my appeal. Basically, is he still alive, is what I'm reading there. In support, the appellant states the following. 1, an order was filed with the 9th Judicial Circuit by the Circuit Court Judge Michael S. Kranick, appointing appellate counsel on December 18th, 2024. Court-appointed counsel Joshua E. Adams had sent a single basic introduction via inmate messaging to appellant on February 27th, 2025, asking if she had any information and to not hesitate to contact him with. It's a weird sentence structure, but we'll take it. I get the meaning. The appellate has attempted to contact Mr. Adams via inmate messaging 5 times and sent 2 handwritten letters to his office in efforts to receive status of her appeal, to confirm receipt of her correspondence, to ensure his representation was and is still active, and no response from him. To present date of this inquiry, appellant has not received any type of response or correspondence in any form or manner from Joshua E. Adams, nor has any of her 9 third-party representatives on her behalf via email and phone calls, which go directly to his voicemail. She has 9 third-party representatives. I need names. Ongoing 7 months. Appellant has received 1 message from her court-appointed appellant attorney, Joshua E. Adams. Appellant was recently made aware by a third-party representative that court issued an order on June 13th with a 20-day due date requiring an initial brief be filed or her appeal may be dismissed due to the complete lack of proper and effective communication from her court-appointed appellate attorney. The appellant's appeal is now in jeopardy. The failure of an appointed attorney to perform duties and or communicate with their client cannot be held against an appellant. Dismissal of an appeal under these circumstances would be obvious denial of her due process and effective assistance of counsel. And she cites some case law, Pullen v. State. The failure of appointed counsel to act cannot be imputed to the defendant to justify dismissal. And also Edge v. State, both Florida cases. Appellant further invokes Douglas v. California, which guarantees the right to counsel on the first appeal of a right, and v. California, which outlines the duty of appellate counsel to support the appeal or withdraw following proper procedures, neither of which have been followed here. Appellant respectively requests this honorable court to please advise and take notice of these violations and either compel court-appointed appellate attorney Joshua E. Adams to fulfill his legal duties and communicate immediately, or appoint new counsel capable of necessary communication and representation and inclusion of the appellant. Guess who didn't write this? Sarah Boone. This was written with notes from Sarah Boone, but it was not written by Sarah Boone. I'm not saying this is AI, might be, but this is someone else's writing. This has got to be one of her 9 third-party representatives on her behalf, which wrote this. First of all, Sarah Boone has never numbered her paragraphs in any letter. And the whole date of this 24th day of June 2025 respectively submitted. I wonder who wrote this. I mean, it's definitely the part that is Sarah that jumps out is, I would say, right here when she says 5 times, and she says 5, and she always puts it in parentheses, like she numbers it. You get it phonetically and numerically, or you get it. It's not phonetically. You get it in letters and numbers every time she does any sort of counting. The ongoing 7 months. So those were the notes from her. And I think she might have written this section right here, but I just don't think she wrote this. Huh. If the case law doesn't actually exist, it's ChatGPT. Well, here's what I will say. If what is contained in that letter is true, she is 100% right, to my understanding. It would be depriving her of due process if they appointed an attorney to do something. She's tried to work with him. He won't respond, and a due date comes and goes, and she loses the ability to appeal. That would be wrong. One of the few wrongs that Sarah Boone has truly suffered in this situation, verbally and numerically. There it is. EDV pointed out the postage was from Reading, Connecticut, so it definitely someone else. Aha. Yeah, well, the legal terminology or the legal sentence structure is the giveaway. She's excelling in all things she is doing. She's almost ready to pass the bar, maybe. All right. It's too clean for Sarah. It is a little bit. And by that, I mean, there was no other complaint. Every letter we've had from Sarah has a bit of a chip on a shoulder type feel to it, where she is upset with a number of things, right? A number of people, a number of instances, a number of, the grievances list is typically longer than one. And this one is just one, which is interesting. I think they took some notes and just reworded them a little bit, but she has a jailhouse attorney advising her. Maybe that's it. Okay. All right. Hold, please. I've got to get something from my renter. We're waiting for an urgent package for the renter. thought we had somebody come up, but it was nope. All right.
Subject matter jurisdiction.
Subject matter jurisdiction. We can do that. Let's jump right now to Judge Simpson.
Cost. Are you expected out anytime soon? What?
Don't know. He's been referred to recovery court on his felony cases in the circuit court.
Got it.
So that process is just.
All right. So what I'll do is $180 fines and costs payable by December 31st, 2025. On the other case, what are we doing?
I just asked for an adjournment to the next possible date. Hopefully we can work something out and.
All right. August 6th, 2025, 9 a.m. All right. Thank you.
Thank you.
Fine. Order.
Is that an interpreter down there?
They don't have them.
Yes.
Huh?
Jayesh Patel.
Custody now. So closely.
Judge's cameras.
Court does call the case People versus Nadia Cosley. Oh, they do.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Cosley. Ms. Cosley, please state your name for the record.
Nadia Cosley.
Thank you.
So, Your Honor, I believe we have resolutions on both cases.
She just disappeared again.
On the Fink case ending in 02.
The Pittsfield case, but go ahead.
I'm sorry. Yes, you're right.
Is she working at Subway right now?
The Pittsfield case ending in 0291. Ms. Cosley has her permit, and Mr. Stiller has extended an offer of double parking.
That's correct, Your Honor. So I move get count to double parking in case 0291. If you accept that admission, we can dismiss your regular charge.
I think she works at Subway. Eat fresh.
Ms. Cosley, do you admit responsibility to the fact that on March 6, 2025, at the location of Ellsworth Road in Pittsfield Township, Washington County, State of Michigan, that you double parked a motor vehicle?
Yes.
All right, court will accept that admission. Count 2, count 1 is dismissed in that case, and that being the case, 291.
Isn't that just an obvious
Fines and cost of $180. When can you get that paid, ma'am?
In the next 2 weeks. So like 14 days.
Yes, I know what 2 weeks is, but thank you for that. Paid by July 31st.
Okay, thank you.
All right. And what are we doing on the other case?
And can I get mine toasted, please?
Offered an account 2 of no proof of insurance 257326, the civil infraction.
Ms. Cosley, that fine is $155. Do you want to accept that? It's a civil infraction, so similar to the other one.
It's $155 for the no insurance case.
Correct.
I can accept that fine, yes.
Pardon? What'd you say?
Yes, I'll accept it. Sorry.
Okay. So on that case, you admit responsibility to the fact on April 26, 2025, at the location of Ridgewood Drive, Pittsfield Township, Washington County, State of Michigan, that upon the lawful request of a police officer, you are unable to provide insurance.
Yes.
All right, court will accept that admission to no proof of insurance. Fines and cost of $155. When can you get that paid?
3 weeks.
You get paid every week?
Yes, I just have my DTE and my internet and phone bill due this week and next week. I have a little budget on my fridge of my checks and bills.
Good.
Okay, that's wise. All right, she's got to squeeze this into her budget.
Yeah, I'm trying to be very responsible with my first apartment.
Your first apartment?
Yes.
Okay, that means she's cash poor. So, ma'am, pay this by August 29, 2025.
Okay, thank you.
You're welcome. Have a good day.
You too.
Court calls the case People versus Dion Covington.
That's funny. I've got a budget on my fridge. I'll see if I can work the court into it.
Good morning, sir. What's your name?
Dion Covington.
All right. You are before the court on a misdemeanor citation or complaint that alleges that on or about June 23rd, 2025, location of Carpenter near Center Valley in Pittsfield Township, Washington County, state of Michigan, that you did possess drug paraphernalia. You understand that, sir?
Yes, sir.
That is a misdemeanor punishable by up to 90 days jail, $500 fine plus court costs and any substance abuse treatment. You understand that, sir?
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney?
Yes.
Yes,
Yes.
sir.
All right. It's a public defender.
Good afternoon, or good morning, sorry. Assistant Public Defender Lauren Perny on behalf of Mr. Covington. We waive further reading standing to the charges as for another pretrial.
Defendant every way formal reading standing mute. Court will enter a not guilty plea. I'll adjourn the pretrial in this matter August 6, 2025, 9 a.m.
Red Pen, I got evicted from the courtroom.
Is he going to be still in?
Failure
He's
to pay rent.
is set for sentencing today. There's a sentence agreement or recommendation to probation, so he should be released.
Okay. I'll set his bond then at a $5,000 personal recognizance bond. In this case, standard conditions: no assault behavior, possession of any weapons, no alcohol, recreational marijuana, or any illegal drug. You understand that, sir? What is he being sentenced on in the other case?
Possession.
It's another drug case. All right. What I'm going to order then is that the defendant also report over to Community Corrections upon his release for what's your drug of choice?
It was for cocaine, sir.
Cocaine? All right. I want testing 2 times per week. Okay? All right. I'll sign that order. Court calls the case People versus Ashley Pickles. Not so much. Court does call the case People versus Shania Williams.
Did you guys hear Beyonce got some
Good
music
morning,
stolen?
Assistant Public Defender Lauren Perny on
Unreleased
behalf of Mr. Miss Williams. Miss Williams, please state your name for the record.
Shania Williams.
Thank you.
Your Honor, this is a licensed case. Miss Williams was released from custody last week. She is getting back on her feet. She has a ticket that she needs to pay off. And to pay that ticket off, she needs to get back working. So
She isn't back
we're
on her feet
asking
yet.
for an adjournment to allow her time
September
to do so.
3rd. All right.
Yes, sir.
2025, 9 a.m.
Thank you.
She just woke
Thank
up.
you. Bond continue.
Thank you.
She just woke up.
All the rest are in.
Yes, sir.
Okay. Court does call the case People versus Ashley Fitz.
Conrad Silver on behalf of Pittsfield Township.
And Assistant Public Defender Natalie Pate with and on behalf of Ms. Fix, who stands to my right. Please state your name for the record, ma'am. Ashley Ann Fix.
Thank you.
Thank you, Your Honor. There is an offer in this matter that Mr. Siller extended that would require Ms. Fix to engage in some mental health treatment. I have reached out to jail services regarding her potential participation in CMH while she is there. She is currently serving a sentence and expected to be released in early September. So all that being said, I'm respectfully requesting a adjournment of this case so that she can engage in those services.
Did you want this October or August or September day?
I think August would be okay, Your Honor.
Turn the matter August 6, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
All right, we're just waiting for
Counsel, so that you're aware, we'll probably slow down only because I only have in custodies left. So we're just
we're gonna slow roll the rest of this.
Court does call the case of People versus Matthew Fonseca. Finesca.
What was the defendant's name, Your Honor?
I think it's Finesca.
Oh, Conrad Silver on behalf of Pittsfield Township.
We're gonna jump to Judge Webster.
Good morning, Assistant Public Defender Lauren.
Reporting probation. The lane.
Brent White is like standing next to a telephone pole, looking down,
Where do you work?
I work at Spirit.
and he's talking.
Oh, that's right. Okay. And you're married and you have a child and a child on the way.
Yes, Your Honor.
And
How
Your
long-
Honor, if the court is going to consider this, the state would request the opportunity to be heard on that issue.
All right. So, how long have you been married?
I've been married for almost 3 years now.
And you've worked at Spirit how long?
Believe this is my 8th year, going on 9.
All right.
Spirit Airlines.
And what's your education?
High school.
Okay. And why are you asking that I reduce it from a year?
I just don't like having things hung over my head for a long amount of time.
I just don't like long sentences. I'm sorry.
Are you thinking you might have trouble staying in compliance with the law for a year?
No, Your Honor. I've gone 5 years without anything. So I was hoping to just not have something hanging over my head for another year. I should have just done this 5 years ago and been done.
Okay, very well, thank you. Now, Mr. Regier, your response?
Your Honor, this is a defendant who the state understands has a history of multiple convictions within the recent past. If the defendant is opening the proverbial door for requesting an amendment to the state's recommendations, the state would offer its own amendment of reporting probation for a year.
Well,
See if the judge and Mr. J. Regier are on the same page on this one.
I will leave it at 12 months non-reporting. That's not to say, Mr. Winters, if you're doing really well, somewhere around the 6 or 8 month mark, if you want to reset it for rehearing, we can do that, but there aren't any guarantees.
No guarantees.
Okay, Your Honor.
At this time, 12 months non-reporting probation with 3 conditions. Has he made the appointment to get his picture and prints taken?
He's already made the appointment.
All right. So, see, the only thing you're basically going to have to do is not violate the law if you keep that appointment. And you better, or it's a violation of probation.
What kind of watch
Thank
is
you,
this
Mr. Winters. We'll be in recess at this time.
Is that like a Rolex?
Okay, here you go, bud. Go pay your fine.
Where's this at?
Clerk's office, right down the hall. Next one up, I have Ryan Miller. Ryan Miller. Okay, hey.
Yes, sir.
I missed what Cheryl Hauser's mug said.
I don't
I have to watch that.
still need
Super T gifted a membership. Thank you very much.
Right.
Hanging with
We
the
are on
ends.
the record in 2025 TR 859, State of Kansas versus Ryan A. Miller. Jared Regier for the state. The defendant, Ryan Miller, in person and pro se. You are Ryan Miller?
Yes, ma'am.
Okay, you're here on one count of driving without valid tag or registration. This is an unclassified misdemeanor. The penalties could be up to $2,500 fine and 30 days to 6 months in jail. Those are the extremes. Normally we see about a $50 fine and maybe reporting probation. There is a diversion program, but you do have to pay more for that. You have to qualify. You have to have a good record or no record. And
We're just court hopping for now.
you have to do other things required, but you are welcome to look into that. Are you going to hire an attorney, apply for court appointed, or represent yourself today, Mr. Miller?
Represent myself, I believe.
All right. For the record, you know you can hire or apply for court appointed,
Yes.
but you want to waive your right and represent yourself.
Yes.
Is anyone making you waive your right to an attorney by threats or promises?
No, ma'am.
All right, then the officer has a form for you to fill out.
Sure.
We will, but we don't have one today unless we go to a sentencing, which I think might last 2 weeks. A
Okay, he
sentencing.
signed it, Judge.
All right.
It was pled guilty.
Now, on this charge, ignition charge, Class C misdemeanor, do you want to plead not guilty and set this for trial? Plead guilty or no contest, meaning you don't admit it, but you don't want to deny it. That's no contest plea. Either way, you'd still be found guilty and we'd proceed to sentencing today. Or do you want to look into the diversion?
I'd like to do the diversion, and I'd also like to say that I have the bike registered and everything. I only rode it that day to work because my truck was broken, but I brought the registration of the bike and everything here for proof.
Have you looked into diversion to see if you qualify for that? It looks.
I'm not sure. The lady on the phone who called me 8 months or however long it's been after that actually gave me the date to come here, told me about it, and I said I wanted to do it, and then that was the end of the conversation. She wasn't
Well, you can
the
look
biggest
that up.
conversation was.
You can look it up at bucoks.com. You do have to qualify. There is an application fee of at least $50. I don't know how much it is. There's also an acceptance if you're accepted fee, and I'm not sure how much that is. I've seen $250 on some of these, but on a registration, I have no idea. But you can look that up, and I'll continue this. But you get on that today and get it done. My calendar is so crowded, I can't let you wait until the next court date and then apply. If you want
Right.
it, get on there and get it done.
So if I have to come back to court for the diversion thing, whether I get approved or not.
If you are approved and you're signed up and diverted, you will not have to come back.
Perfect.
All right. So when is the next date for a diversion review, Destiny?
Your Honor, that date is October 22nd.
You'll need to be back here October 22nd, 9 a.m. if you're not fully diverted.
Okay.
All right. If there's nothing further, we'll be in recess.
Perfect. Thank you.
You're welcome.
Anything else for me?
No, we're here. You're done.
Yes, sir. Thank you.
Okay, next one up I have is Malaya Sharp. Malaya Sharp.
We are on the record in 2025, TR 18, State of Kansas versus Malia LeRae Sharp. Jared Regier for the state, Malia Sharp, the defendant, in person and pro se. You are Miss Sharp.
Yes, ma'am.
Okay. You failed to appear at your first appearance, April 9th, 2025. So I will advise you that in count one, you're charged with driving without a seat belt. This is punishable by a $30 fine. In count two, you're charged with driving without proof of insurance, a Class B misdemeanor. If convicted, your fine would be at least $300, but no more than $1,000. And your jail sentence could be anywhere up to 6 months. Are you going to have an attorney represent you or waive your right to an attorney, Ms. Sharp?
Waive my right.
Is anyone making you waive your right to an attorney by any threats or promises?
No, ma'am.
And you know you can hire an attorney, and if you cannot afford one, you can apply for court appointed?
Yes, ma'am.
All right, the deputy will have a form for you to fill out.
Print your name there, read it, and sign it down. Okay, she got it signed, Judge.
Thank you. Now, Ms. Sharp, were you going to look into diversion, enter a plea, or set this for trial?
I didn't know if I could do a diversion. I also have a case in Sedgwick County as well, because I got pulled over within a month apart.
And I see you have something else on the record. It's rather old. Yeah, they probably won't divert with 2 cases pending, but that's not my call to make.
So
how do you want to proceed?
I'll just enter a plea today, Your Honor.
All right, how do you want to plead?
Guilty.
You want to admit that you were driving without insurance as alleged?
Yes, ma'am.
Is anyone making you enter this plea today by any threats or promises?
No, ma'am.
And you're pleading guilty because you believe you are in fact guilty?
Yes, ma'am.
And do you understand that if I accept this plea, you will be found guilty and unable to appeal your conviction?
Yes, ma'am.
Understand there will be no trial. You're giving up your right to that?
Yes, ma'am.
All right. And were you driving in Butler County on January 1st of 2025?
Yes, ma'am.
Do you remember what roadway you were on or highway?
Ohio Street.
Between Augusta and El Dorado?
Yes, ma'am.
Did you have insurance on your automobile at the time?
No, ma'am.
And I do find that you are knowingly and voluntarily entering this plea, and I will find you guilty of driving without insurance. You had no insurance.
I do now. I didn't then.
Okay. All right. Having found the defendant guilty, I would ask Mr. Regier if you have recommendations for sentencing.
With all due respect, Your Honor, this does appear to be a case where there is a second charge currently before the court, and the state is not aware of any amended information filed with the court in this case.
All right. So she's pled guilty to insurance, and you're pursuing the seatbelt charge, Mr. Regier?
The state's understanding is that issue is still currently before the court, Your Honor.
Ms. Sharp, did you have how do you plead to the seatbelt charge?
Guilty.
Were you wearing your seatbelt at the time you were stopped for having insurance?
No, ma'am.
No insurance? All right. And no one's making you enter this plea?
No, ma'am.
All
right. I'll find you guilty of that count too, Mr. Regier.
Yes, Your Honor. At this time, the state is recommending for count 1 the statutory fine of $30. With respect to count 2, the state is recommending the statutory minimum fine of $300, that the court impose court costs, and that the court impose a 120-day suspended jail sentence subject to 6 months of non-reporting probation. It would appear that there are no court costs with respect to count 1, only count 2 as required by statute, and I will defer to the court as to any issues concerning repayment of this matter.
Ms. Sharp, you don't have to say anything, but if you have anything concerning a sentence before I determine it, you may say it.
No, ma'am.
All right. I do, on the seatbelt, impose the scheduled fine of $30. On count 2, the insurance, the minimum fine required by law of $300, and court costs of $108 for a total due of $438. Can you pay that today, or do you need some time to pay it?
I need some time, please.
How much time? 30 days, 60 days, 90 days? How many?
60.
All right. You think 60 is enough?
Yes, ma'am.
All right. I will order that you pay that within 60 days of this date. Concerning jail sentence, a suspended 120-day order. Now, what that means is that
another snotterly.
It is ordered, but it will be suspended so long as you successfully complete a 6-month non-reporting probation. For 6 months, you will be on probation. You don't have to report to anyone, but you have two conditions. Number 1 is pay the total due within 60 days. And the second one is to violate no laws. Looks like you're already on bond, so you don't have to have your picture and prints taken.
Judge Webster's in Kansas, I believe.
So again, 120-day sentence. You don't serve that unless you violate your 6-month probation, 2 conditions, pay within 60, and violate no laws. Any questions about that, Ms. Sharp?
No, ma'am.
All right, stop by the clerk's office and they'll tell you how to make the payments. There's several different ways you can do that.
Okay.
All right, if there's nothing further, Mr. Regier, I do find she knowingly and voluntarily waived her right to counsel orally and in writing.
Thank you, Your Honor.
Nothing further, you may go, Ms. Sharp.
Thank you.
Thank you.
Brady Bunch continues here.
Next up is Holly Schwartz.
This court security, this is actually these are people who showed up in person to the courthouse and are using the courts. They're not in custody. They're using the court's
We're
computer.
on the record in 2021, TR1, look that one up.
It's windy outside Mr. Gear's office. Windy in Kansas.
We're on the record in 2021, TR3133, State of Kansas versus Holly Ann Schwartz. Jared Regier for the state. Defendant Holly Ann Schwartz in person and pro se. You are Holly Schwartz?
Yes.
All right. Ms. Schwartz, you failed to appear June 1st, 2022. And a warrant issued for you to appear with bond set for today. In count 1, you're charged with operating a motor vehicle in Butler County, Kansas on November 19th of 2021, at which time you did not have a valid driver's license. This is a B misdemeanor. If convicted, you could be ordered to serve up to 6 months in jail, although probation is an option. You could be ordered to pay up to $1,000 in fines, although something much, much less is usually imposed.
Much.
In count 2, you're charged with operating a motor vehicle without
something.
Without proof of liability insurance. That is a Class B misdemeanor. It carries a fine of anywhere from $300 to $1,000 and a possible sentence of 6 months, although probation is an option. And then count 4, you are accused, and count 3, you're accused of operating a vehicle with an expired tag or other registration issue, an unclassified misdemeanor. Brett White, could you please stop moving around? You're distracting.
Brett, sit down.
Count 3,
sit down.
Operating a motor vehicle without registration or expired tag, an unclassified misdemeanor. The penalty could be anywhere from 30 days to 6 months, although probation is generally imposed. Your fine could be up to $2,500, although something much, much less at the lower end is usually imposed. And then count 4, failure to wear a seat belt carries a fine of up to...
Brent's going to be in trouble here soon.
Well, a scheduled fine of $30 and no jail time. So at this time, I kind of stumbled around on those, took a little bit of time. Do you have any questions about those charges, Ms. Schwartz?
No, ma'am.
Brent's stumbling around too.
And do you intend to have an attorney represent you on these charges?
No, ma'am.
Well, you can hire an attorney, and if you cannot afford an attorney, you can apply and see if one can be appointed, or you can waive your right to an attorney and represent yourself. So which way did you want to go?
I'll waive my right to an attorney.
You can have an attorney.
Yes.
All right. And is anyone making you waive your right to an attorney?
No, ma'am.
All right, then I will have the record reflect, both in writing and on the journal entry, that you have waived your right to an attorney on record, both in writing and orally.
Okay.
And Mr.
She's got it.
Regier? Okay, and Mr. Regier, since she's representing herself, do you wish to negotiate any outcome with her?
One moment, Your Honor.
When does Donna Adelson start? Have you guys said that? Did I ask you all that already? The Adelson matriarch murder trial. It's called a couple different things. August 18th. Okay, so that's probably our biggest pending case right now, which is that'll be after I get back from Idaho. There are a couple others. First of all,
Your Honor, I'm not sure if the court wishes to address at least the prospective possibility of diversion at this time. The state does acknowledge that this is an old case, but the state only brings it up for, if no other reason, equal protection purposes. For purposes of judicial economy and resolving the case today, as this does appear to be quite old case, the state would be prepared to dismiss count 1, no valid driver's license, in exchange for a guilty plea as charged to all remaining counts.
That's fine.
Are you interested in the diversion program, Miss Swart? I don't usually like to postpone cases this old for diversion, but the county attorney is apparently mentioning that as a possibility. They're not saying you have diversion, but you can apply if you want.
Where's Brent?
I don't know what diversion is.
Kim Ton's Jewelry.
Okay, that's the program I've talked to you this morning. If you want to pay the diversion application fee and apply online, they will look at your record and charges and decide if you qualify, they being the county attorney's office. If you qualify and they approve diversion, you will fill out a contract to do certain things, including pay your fines and costs, plus a diversion fee of, I think, for some reason, I think it's $250, but I wouldn't swear to that. It's not my program. The application fee, as I recall, may be
Not my
$50,
circus,
but I don't
not my
have
monkeys.
figures for that either. But you're certainly, if the county attorney wants to consider you for it, you can do that.
I'll pass on it, I guess.
Well, I don't want you to feel like you have to pass on it.
No, I don't feel like I have to. I live 300 miles away, so I would just like to get it all resolved today. So.
All right. Well, as I understand it, the diversion can be applied for online and the contract can be handled through the mail. But I certainly will respect your wishes and proceed today if you want to resolve this today.
Okay.
So,
yeah.
How do you want to proceed?
Yeah, I want to proceed.
All right. So the county attorney has said they will dismiss count 1, one of the B misdemeanors, if you want to plead guilty to 2, the insurance with a minimum fine of $300, count 3, the registration, and count 4, the seatbelt. Do you want to accept that offer?
Yes.
All right. Is anyone making you accept this plea offer by any threats or promises?
No.
And do you understand that if I accept this plea, you will be found guilty of these 3 charges, proceed to sentencing, you'll be waiving your right to trial, and you'll not be able to appeal the conviction?
Yes, ma'am. Does it make any difference that I have liability insurance now and all that? No.
Well, apparently not for the plea agreement, and it doesn't excuse the charges. But it will probably help you with your driver's license going forward.
Okay.
All right. So you want to proceed with the pleas?
Yes.
Are you
Yes.
pleading guilty because you believe you are in fact guilty of these charges in Butler County on November 19th of 2021?
Yes.
And can you tell me in your own words what you did that makes you guilty of these 3 charges?
I didn't have liability insurance. My license wasn't valid and the car wasn't registered.
And did you have your seatbelt hooked?
I don't remember that.
Was it triple whammy?
But we'll go with no.
All right, so you want to plead to that to take advantage of this plea offer?
What is
Yes.
Brent hiding? There's something above him that we don't get to see.
And Your Honor, if the court is considering at least a prospective Alford plea with respect to count 4 solely, the state has no objection, again, for purposes of resolving this case today.
If the officer on his ticket says that he saw you driving on the Kansas Turnpike, I-35 highway at mile marker 74 south in Butler County, would you take any issue with that, or would you agree that that's where you were?
That's where I was.
Okay. All right, I do accept your plea and find you guilty of counts 2, 3, and 4. Recommendations, if any, for sentencing, Mr. Regier.
Yes, Your Honor, as 2 preliminary matters, does the court find that the defendant has in fact waived her right to counsel on the record? And if so, do I have the leave to journalize that from today's hearing? Additionally, for purposes of the journal entry, the state would be requesting clarification on the record as whether or not the defendant has entered a guilty plea or an Alford plea with respect to count 4.
Yes, an Alford plea. To count 4. All right, sentencing recommendations.
Yes, Your Honor. With respect to count 2, the state is prepared to recommend the statutory minimum fine of $300 and court costs. The state is recommending the maximum underlying sentence for a Class B misdemeanor of 6 months. With respect to count 3, the state is recommending a $50 fine and the maximum fine allowed by law of 6 months concurrent to count 1, subject to a 12-month non-reporting probation. The state is recommending the statutory minimum fine of, the statutory fine of $30 with respect to count 4, and it is the state's understanding that insofar as count 4 is concerned, court costs do not apply as required by statute.
Miss Schwartz, where do you live? You said 300 miles away?
Yes, I live in Kansas City, Missouri.
Missouri? What are you doing in Kansas? Probably just across the border.
At this time, Ms. Schwartz, on count 2, liability insurance, your fine is the minimum allowed by law of $300. And your sentence is 120 days. Suspended on count 2, $50. And 30 days suspended concurrent. Okay, count 2 is actually the insurance. On count 2, the insurance, $300 on 120 days. On count 3, the registration and tag, $50 and 30 days suspended concurrent. Count 4, $30, no jail time. Court costs $108 for a total due of $488. Can you pay that today?
No.
How much time would you need to pay that?
Can I get 90 days?
90?
I will give you 90 days to pay that. You can make payments so that you don't have it all just snowball and hit you within 90 days. Now, if you don't want to serve this jail time, You must
Judge McNally's in a
successfully
rage.
complete a 6-month non-reporting probation.
Okay, hold up. Let's find McNally. Sorry. Let's back up just a little bit. This is current case. Let's hear this one. Okay, thank you, Josh. I was investing in what Brent did. I'm sorry.
Stay seated.
Court is back in session.
Let's go. We gotta get some cases done.
We got to get some cases done. Come on, let's clear this document. Judge means business to start. Don't slow him down. Empty courtroom. Where are my defendants at?
Up against James Robert Adams, 25BA 23708.
Right to the podium.
There he is. Way back there in the back. Come on, move with purpose. Move with purpose, as Judge Boyd would say.
Your name?
I need to move.
James Robert Adams. All right, so you're charged with a violation of probation. They think you failed to provide proof of your animal license by May the 4th of 25. That is the charge. If you plead guilty or if you're found guilty, your 771 status could be revoked, conviction entered, you'd be subject to a 90-day jail term. Do you understand that? Yes. Did you sign, read, and understand the advice of rights?
Yeah.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
You have the right to a lawyer. I'll be happy to provide you with one at public expense if you cannot afford one, or even if you can't afford one, I'll give you one. You want a lawyer?
I have one.
Where's he at?
Well, I thought today, because all the information that I had given you with Emily, she said, just kind of bring it in and make talk over.
There's no talking anything over.
Well, I mean, that's what Emily said, you know, she said all the text.
The only reason this lingered, just so you know, this long is because I had no knowledge that you didn't have that dog licensed.
Well, I tried to, sir.
Listen.
I've got all the tests. I've got the State Department here. I've got the doctors here. I tried to have him.
Listen.
Twice.
Listen.
And then I know, but she said that you would take a look at all the evidence.
I'm not about to overrule their ordinances.
It's 106 years
Listen,
old.
hang on. I don't give a, I could care less.
Did you, I mean, the State Department wrote a letter.
State
Department. If the State Department wants to enter an appearance and Pam Bondi or whoever else wants to come in, they can come in here and represent you if that's what they're choosing to do. I don't care if it's the State Department, the Department of Justice. I ordered you to have this dog licensed. It came to my attention 2 weeks ago that you didn't.
I tried.
Hang on. It's very simple, Mr. Adams. I can't believe we're still going through this.
I can't give him the test. He's gonna die. You're gonna kill my dog.
I'm not gonna kill your dog.
If he gets that vaccine, he will die. He almost died before.
So,
should I just put a bullet and go home and put a bullet in his head?
Hang on a second.
I mean, I can do that. Just get it over with. If that's the ruling, then I'll just go home and put a bullet in his head. That way he doesn't have to suffer. You ought to see what he went through. It was horror.
Listen.
And now you want to kill my dog? And this, who's going to be accountable to that? I can't, I mean.
He hit the gavel.
He can't have it. I'll.
He hit the gavel again.
Your dogs have been running around. If I took the top 1% of 1% of 1% of 1% of 1% of 1% of 1/2 of 1/99th of 1/2% of people who've had dogs running around, it's between you and your wife. Don't say a word. I am not the legislature. I am a judge. I'm not arrogant enough to ignore laws and rules. The rule is that in order for your dog to be licensed in Brownstown, they have to have shots. Hang on, let me finish. I'm not a member of the legislature. If I wanted to run for the legislature, I would have done that. I still could, I suppose. I'm not too old to do that. I don't make up my own rules here. I don't know what I got to do to make you understand that.
One dog is licensed.
1 out of 2.
I tried to do them both.
Listen.
Once.
Listen.
He cannot have the shot.
Listen.
He will die.
Listen.
I have the proof of it for it. He cannot have the shot. I was not negligent. I have been trying and trying and trying. I don't know what else to do other than kill him.
Nobody wants your dog to
Well,
die.
if you vaccinate him, he's pretty much dead. You ought to see what he went through before. Listen. I thought I was gonna have to put him down before.
I don't think.
He made it.
Listen.
The doctors are recommending for me not to do it.
Call in the prosecutor.
Call in the prosecutor.
It is a criminal violation for a dog not to be licensed. Period. Listen. It is a criminal violation for a dog not to be licensed. In order for a dog to be licensed, the dog has to have its shots. It has to, hang on, let me finish, please. It has to be vaccinated. Now, what you're saying to me is, be a god, be a king, and just say the hell with their ordinance.
It's a good sound.
They don't, you can overrule their ordinance and say, it's, whether you want me to say it's unconstitutional or I'm not going to enforce it. That's not what judges do.
Your Honor.
I want you to listen to me for a second. That's what you want me to do. I can't do that. The dog, if we're going to have a big hearing with experts and say that this dog is going to die, you're going to have to bring in more than a letter. You're going to have to bring in the doctor, the vet. I presume you have that from, right? You have that from a vet?
Yeah, you have the letter.
I don't, just so you know, Mr. Adams, I don't read things that are sent to me unless they're sent to the other side. I don't know if this was sent to the prosecutor or not.
Emily said she was.
She's not, well, Emily talked to me about this, and I was not real enthused about the fact that this had been going on without me having knowledge of it for several months. When I told you to have the dog licensed, I know I gave you a date here. Must register within 30 days, and that means by May the 4th, and this wasn't brought to my attention until early July, so I don't want to air dirty laundry, but I was not enthused that order had been not complied with, and nobody told me about it until 2.5 weeks ago, at which time I told them immediately set it for hearing. Ms. Foley Carter, your name?
Caitlin Foley Carter, Brownstown Township.
Have you seen any of this documentation?
Emily did send it to me, and Mr. Adams has been talking to Justin Donosky, the Director of Public Works, who is in the courtroom. Mr. Donosky has been in contact with the state. The state reiterated our position is that there are no exceptions or exemptions to not getting the rabies vaccination.
Okay.
Say that again. I want to make sure I heard that correctly.
Certainly. The state confirmed our position that there are no exemptions or exceptions to not getting the rabies vaccination before being given a license.
You of all people who've had your dogs running all over the township, you and your wife, I'm telling you, this is like take the dog at large cases I've had, and I don't care what the township's done with them. They pled some to civil infractions. They dismissed others. I've had more dog cases with you and your wife in here than any 4,000 people times 10. And I'm supposed to let this dog run around and bite somebody? You know, people fight, dogs bite.
He's good. He's passed the test. The tiger doesn't, he has the antibodies. That's what my attorney was telling you. Bobby was in here saying, hey, he's gonna get a titer's test. That was the whole, he was standing right here. We all talked about the titer's test. He said he's getting the titer's test to make sure he has the antibodies. He can't get rabies. He has the antibodies in him. And as far as Kansas State, where this was done,
Hang on a
they
second.
issue the license.
Hang on. All I know is that the stipulated plea agreement.
You can't amend this and try to fix it for a remedy, because there needs to be.
Fix it for a remedy. What? Ignore the Brownstown
No,
laws?
it's 106 years old. They didn't have this technology 106 years ago. That
Then
ordinance.
you can, I can't just declare this unconstitutional.
It's not, just have a remedy. If you pass the test, why can't you be good? I'm not the only one that has this issue.
I've never heard it from anybody else. I've been here for 31 years.
Dog's license. That's what they tell me. You know, they won't even do it because they don't want the vaccines.
You guys signed, hang on.
I want to do
I was a little shocked by that too with your lawyer, if you don't mind me saying. Hang on. He's bringing up something at the time of the plea, and you guys signed a plea agreement saying, let me just pull it out here. I don't want to misquote it. Must register and obtain licenses for all animals in the home within 30 days. That's in part and part. I ordered that. You're not obtaining a license. They're not given a license. I don't know if the township hasn't even been in existence for 106 years.
She quoted on here that it was the law was from 1919.
It could be by statute, but it's not the ordinance.
So
they haven't been in existence that long.
For the state.
How long's the township been in existence?
Not that long. I believe he's talking about the dog law.
The dog law, 1919.
It's a
requires
statute.
licensing to enforce.
Sir.
I want to do the right thing. I've been trying.
I'm going to let you appeal this.
I can't.
I'm going to let you appeal this. You can appeal this. You can take this up to the circuit court and then to the Court of Appeals, and if need be, to the Supreme Court.
Somebody needs to do it. It's not.
Do it. I am not about to carve out an exception for you or anybody else or myself. Now, I'm not going to argue with you. You want to get your lawyer here and you want to contest this, you feel free. I'll give you an opportunity. I'll adjourn it a week.
Okay.
But my patience is running thin because I have been told, I was not told about this, or I promise you this would not have lingered this long.
I kept in touch with Emily the whole time.
She told me that.
Even when I wasn't supposed to come in, I kept in touch with her.
She told me that.
I would just stop by and talk.
She told me that.
So I'm trying to do it. I really am. And this is not.
Have you seen this report that he has?
The titter test from Kansas State University I did. It's not a replacement for the rabies vaccination, however.
They say it is.
The state or the township doesn't.
I mean, the Kansas does. They're the ones that do all the.
She's saying, did you hear what she just said? The state isn't saying it is, the township isn't saying it is. So, nobody wants your dog to die, Mr.
Well, they will
Adams.
if I give him the test. He's got a really good chance of dying.
Bring in the vet. I want to talk to this vet. You bring in your vet and you bring in your lawyer, okay? I'm going to have some questions for him. She's going to have some questions for him. I cannot just allow a dog to run around that could create rabies, especially with the history that you and your wife have with letting dogs run around. I mean, if you want to buy every house in the township in your subdivision and get them to rezone it and let you build a park with a fence about it, you can run your dogs all over the place. But this is ridiculous. I'm not negotiating.
Why don't you just get rid of it?
You do what you want to do, but I cannot. I don't think you're understanding me. I cannot and will not ignore laws. Good judges don't do that. I don't write my own laws up here. I never have, and I'm not starting today. I can't just say, forget the township. It's okay for me to allow you to illegally own this dog and not have it licensed in accordance with their their ordinances or the state statutes. I can't do that. No decent judge in the country will do that.
You know I haven't tried, well, that wasn't my intentions.
Well, I'm telling you what it is. I'm just telling you.
But you understand that that was not my intentions of doing that. I am trying.
Nobody said it, you weren't trying. She's told me you were trying.
And then this
listen, I'm gonna adjourn it. You have to understand, I'm gonna tell you one last time. I can't imagine what a vet is going to be able to tell me where I'm going to say, yes, you can disregard their ordinances. I mean, anybody who knows me knows I would never say, yeah, it's okay if you illegally own this dog. Did you hear what I said? No, I don't have that kind of power. I'm not a king. We have 3 branches of government. All of a sudden in this country, we got all kinds of people that think they have all kinds of power beyond what they have, and I'm not one of them. I have the power to adjudicate, interpret, and make decisions in accordance with the law. I took an oath with that, and I'm not breaking it. Tell me when you can get your vet here. If you want to go make a call and find out when your vet's available, I'll ask them to come in a separate day so I can accommodate them. And you can get whoever lawyers you want and bring them in, and we'll all have a nice little conversation. But I'm going to tell you, at the end of the day, my saying you don't have to comply with an ordinance, I can't imagine what I'm going to have to hear. So if that's what you think it is, you might want to save yourself some time and money and just make up your mind. I'm going to appeal the judge's decision. I don't agree with him. It's okay. You're not going to be the first one, by the way, Mr. Adams, that's disagreed with me. I've been doing this for 31 years, and I have people disagree with me frequently. It's okay. We can all have the right to disagree. I just know when I go home every night, I can look in the mirror.
Can I ask you a question?
Hey, did you hear what I just said? I can go look in the mirror, and that's all I've ever asked of myself.
Can I ask you a question?
Sure.
If you were in my shoes, would you give your dog a vaccine?
I wouldn't buy a dog if I couldn't get the dog vaccinated.
You don't buy, I saved it.
Pardon?
I saved the dog.
Whether it's a rescue dog or otherwise, I am not big enough in my mind to ignore laws. If I start ignoring laws, I got no business doing what I did. So I don't know what to tell you. I don't know what to tell you. You can run for the township board, get them to change the ordinance. You can do that down the road. Or you can run for the legislature, get them to change the state statute. But judges don't legislate from the bench. Good judges don't make up their own rules. There's a lot of things I've disagreed with in my career here that I've seen on the books and ordinances and statutes. Nobody would know it. I mean, sometimes I get a little lippy because I wear my emotions on my sleeve, but I try not to say what I disagree with when I disagree with the law because it's not my function. But either way, whether I agree with it or disagree with it, I follow it, period. So I have no problem. Go call your vet, call your lawyer, but you're asking me again, I just can't make you understand this enough. I cannot say that it's okay for you to violate laws because I don't like the law. It's not okay.
You can't make exceptions for...
How can I make exceptions?
Not every situation is the same. It's really not. In situations...
You bring your vet. I'm giving you the opportunity to bring your vet, bring your lawyer. Go call them and tell me what day, and I'll try to work with you. Right. Okay? Thanks. All right, let's do...
Wow.
Mackenzie Lynn Goff, 25B148638A and B and C, and I also have 25B, it looks like 80142.
Good morning, Judge.
Sorry for all that excitement. Go ahead, your name?
Deanna, to you on behalf of Ms. Goff, state your full name for the court. Mackenzie Goff.
All right, so first of all, she has a fraudulent scheme. She has a larceny charge. She has a contributing to the delinquency of a minor. Does she stand waive formal reading as to all those?
Yes, Judge.
Now, as I understand it, she is going to plead guilty to larceny and contributing to the delinquency of a minor. The MIP, which is the civil infraction 80142, will be dismissed. And
The fraudulent scheme to also.
The fraudulent scheme will be dismissed, right?
And yes, Judge, she's playing under HIDA.
Okay, so I will do that. And, ma'am, I want you to understand, if you plead to contributing to the delinquency of a minor in larceny, each of those are punishable under a local ordinance by up to 500 fines, 90 days jail. Costs are all those. I will defer the proceedings, set terms and conditions. If you're compliant at the end of a specified period, I'll go ahead and dismiss the case on motion of the prosecutor. Do you understand that? I can't hear you.
Yes, sir.
And did you sign, read, and understand the advice of rights form?
Yes.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes.
All right, nice and loud for me, okay? All right, to the charge of contributing to the delinquency of a minor, how do you plead? You gotta go a lot louder than me.
Guilty.
To the charge of larceny, how do you plead?
Guilty.
Were you at 27232 Crawford in Brownstown, May 12 of 25 at 6:51 PM?
Yes.
What did you do that makes you guilty of larceny and contributing to the delinquency of a minor?
I agreed to sell cartridges.
Hang on, nice and loud, I can't hear
I'm
you.
sorry. I agreed to sell cartridges
Of?
and marijuana.
Up to,
A minor.
okay?
Realized she was a minor and I drove off and I didn't send that money back right away.
What?
Okay, so you,
That's not
you
guilty.
agreed to sell the cartridges to a minor. She paid you the money, then you realized she was a minor. You kept the money and you took off with the cartridges?
Yes.
How old was this young lady?
I don't know exact.
15 years old, I believe.
Do you agree with that?
Yes.
Are you on probation or
I
parole?
was doing the right thing, Judge. I ran away with the
Anybody
money.
forced you to plead guilty?
Didn't want to commit a crime.
All right. I'm gonna accept your plea. I'll accept your plea to both charges. I'm going to have you, I'm gonna set a bond here, and I'm gonna order a screening and assessment here, okay? So I'll accept your plea to contributing to the delinquency of a minor. I'll accept your plea to larceny. I'm going to go ahead and dismiss the MIP charge as well as the fraudulent scheme. I'm going to give you a $1,000 personal bond. Here are your terms. You cannot leave the state without the consent of the court. You cannot violate any law. You must appear in court as directed. No contact at all with the victim. You're not to go near 27232 Crawford in Brownstown. No contact with prosecution witnesses. No alcohol, no marijuana, no illegal drugs. You understand that?
Yes.
And also you have to go over and get fingerprinted and photographed by 1 PM today at the Brownstown Police Department. So you're going to go down the hall, get your new date, and then you'll come back across the hall to probation. You'll fill out a questionnaire and be interviewed, and then you'll come back for sentence. When's the sentence, Lisa?
July 30th at 8:30.
Okay, July the 30th at 8:30. Do you understand everything? Who are you here with?
My mom.
Who's your mom? Okay, how old are you?
I'm 18.
You gotta stay out of trouble. This isn't good.
I'm
You seem like a nice kid. What do you, whoever has the
You gotta
phone,
take that phone out of here, and you gotta take your hat off.
take the phone out, sir. Hey, listen, I'm not in the mood for somebody to get smart with me today, Mr. Caballero. What is going on here?
He's bouncing between the courtrooms, just watch.
Somebody's phone went off. Judge is not having it.
Go down the hall, get your notice, go across the hall, fill out a questionnaire and be interviewed. Good luck. And then make sure you take a copy of the order over to Brownstown, okay? Good luck.
Thank you, Judge.
Aaron James Harper, 25B148510. Come on up, Mr. Harper. Defrauding an innkeeper is the charge.
Defrauding an innkeeper?
You have to move it Hartford Station first name.
Is that like not paying your Airbnb host?
Yeah.
You got gum in your mouth?
Swallow it.
What's that?
Just keep your pocket.
All right,
So, Your Honor, there was an offer extended by the prosecutor, and Mr. Harper is just asking for time to consider that.
no problem.
And then we-
Does he stand mute, waive formal reading?
Yes, Your Honor.
Not guilty, pleas entered. I'm going to give him a $500 personal bond. You cannot go near the Big Bear Lodge. You cannot leave the state without the consent of the court. You cannot violate any law. You must appear in court as directed. No contact with prosecution, witnesses, or employees of the Big Bear Lodge. And I do want you to go over to Brownstown to get fingerprinted and photographed by 1 p.m. today. You're going to have to fill out a court-appointed petition. All right. You're going to have to fill out a court-appointed petition. I'll be happy to do that for you. We're happy to appoint you a lawyer so long as you qualify.
Big Bear.
And again,
Big
you
Bear,
have to go over to
Big Bear.
Brownstown. So first, you're going to go down the hall, get your court date, which will be July 30th, Lisa, at what time?
10 o'clock.
At 10 o'clock. Why'd you miss before?
Your Honor, so they have his incorrect address. I think he was identified by officers, so they pulled up an old.
Lisa, go ahead and get his right address. Will you do that when you go down the hall? Okay. We'll get your new address. Give it to her, all right? Thank you.
Judge doesn't want to hear the
People
story.
against Jade, Patricia, LaShawn, Teet, 25B, 147968A and B. So I have a reckless that's going to be reduced to careless, and I have a resist and obstruct that will be taken under 771.1. True?
Yes, Judge, Dion Patillo on behalf of Ms. T. Say your first name, say your full name for the court.
Jade Patricia LaShawn T.
All right, so she already was arraigned. She's going to plead to careless. She's going to plead to resist and obstruct. Resist and obstruct will be taken under 771.1 for 3 months. True?
Yes, Judge.
If you plead to careless, that's 3 points. I'll dismiss the 6th point. If you plead to resist and obstruct, that's punishable by up to 500 fines, 90 days jail. Costs are all those. I'll take it under section 771.1. And if you comply at the end of 3 months, I'll dismiss. Do you understand that? I can't hear you.
I do.
Did you sign, read, and understand an advice of rights form? If you plead guilty, you'll be giving up all those rights. There will not be a hearing or a trial. Do you understand that?
Yes, Judge, I did want to address that. It is a no contest. Did Caitlin write that on the
Why is it a no contest?
lack of memory, Your Honor?
Was she under the influence of something?
No, the diabetes, her sugar levels had dropped, so she was like,
Okay, if you plead, I'm sorry, I didn't see that. If you plead no contest, you'll be giving up all those rights and there will be no trial. Do you understand that? All right. So lack of memory to the charge. Did she sign an advice of rights? She,
Ivan's on a roll today. Ivan, how are you
yes,
doing?
she did sign one today. Okay. You understand a no
Thank you,
contest plea
AZ.
has the same effect as a guilty plea? Nice and loud for me. All right, you stipulate I can use the police report, true?
yes, Judge.
To the charge of resisting and obstructing officer, how do you plead? To the charge of careless driving, responsible or not responsible?
No contest.
Responsible.
And accept your plea to that charge, dismiss the reckless. I'm reviewing the report. All right, I'm gonna accept the plea based on the factual basis. Are you on probation or parole?
I am not.
Anybody force you to plead no contest?
I did not.
That's why you're upset.
I'll accept that plea. I'll accept the plea to careless driving. Dismiss the reckless. You know, I got a lot of cases in here, I think. You live in Westland, ma'am?
I do.
All right, let's go ahead and sentence her. Give me a probation order, will you, Lisa? I mean, John. All right, counsel, anything you'd like to say?
She is employed at YFL Credit Repair. She doesn't have any children around. She does have some significant health issues right now. That's the main cause of this situation. So I would just ask if the court would take that into consideration for sentencing.
Ma'am, anything you'd like to say on any one of these cases?
No, it's just a new medical issue that I had in March. Started the dialysis has never, I didn't know it would drop my sugar that low. So my sugar has never dropped. I've been a diabetic for about 10 years. My sugar has never dropped, but only when I started dialysis. And they didn't tell me that it would drop or I would never be high. That's it.
That's it. Okay. Sentencing incoming.
All right. I'm gonna simply fine you on the careless driving, $200. Again, the reckless is dismissed pursuant to the stipulation on the resist and obstruct, 3 months probation per the agreement of you and the prosecutor, Ms. Patillo. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. I'm gonna make it non-reporting probation. I want you to pay fines, 100, costs 50. 75 victims' rights fee, $50 justice assessment. So fines and costs are $275, probation fees are $60, attorney fees are $40, your total is $375 or 90 days. I'm going to give you a review hearing date. So I'll give you the review hearing date and you will be careless driving of $200, so $575. How much of that could you pay today?
She needs time to pay.
How much does she have today?
You can't pay anything today.
When can you pay this, ma'am?
Oh, man.
Well, over.
I can't hear you. You got to keep your voice up.
Okay, what are you saying? Can when I can pay the total
Every couple
amount?
weeks.
I can pay every week.
How much?
Like $20 every week. I don't know.
How are you supporting yourself?
I work, but I have other medical issues.
Okay, you pay 20 a week. I'll do that for you. Beginning, I want you to pay, can you start next Friday? So starting July the 25th, okay?
$500, $20
If you don't have the money, no problem, call the court. I'll be glad to go on. And I'll be glad to go on Zoom or you come in here and talk to me and I'll be glad to give you an extension, okay?
Thank you.
All right, so just don't be afraid. I'm not gonna lock you up if you don't have the money. Just show a little courtesy, all right? Good luck. Thank
You want a review date?
Oh, yes, thank you. And we're gonna need to give you a review hearing date, ma'am, so you can come back and get your case dismissed. I'm talking about the resist and obstruct. That'll be when, Lisa?
October 8th at 9 o'clock.
So you go down the hall, get that notice, and she'll explain everything to you. And then I want you to go to probation and they'll instruct you so you don't have to come back, okay? Good luck. Thanks. Nicholas Gilliland. Nicholas Edward Gilliland, 25U57413 A and B. Mr. Gilliland, your name?
Empathy on behalf of Mr. Gilliard, station next to the court.
Good morning, Your Honor. Nicholas Gilliland.
This is really.
He's tall.
Okay, so does he stand mute waveform reading?
Yes, Judge.
I have they cited OWI2. They can't write OWI2 under local ordinance. So it's either they have to take it. Ms. Foley Carter, could you pop your head on Zoom there if you can hear me?
So that's what we discussed, Judge. That was the reason for the adjournment. It should be, I don't know if it's written.
She just said to speak to Wayne County Sheriff's Department.
Right, to determine if it's gonna be charged as an OWI
Call in
second.
Ms. Foley Carter. Yeah, I'm just.
Wayne County or.
Well, they'd have to dismiss this and go that way if that's what they choose to do.
Right.
But
she's trying to, I guess.
Who was this? State Police or Wayne County Sheriff?
The Wayne County Sheriff.
And you were not printed that night, were you?
No, sir. Or you mean like, does that entail booking?
Correct. They didn't photograph you and they didn't print you.
They didn't book me.
T. Kinsella, no, the videos are paramount.
Go ahead. How many priors?
No, she was down here at the window. She's
And we
coming
can't
down.
see him.
How many priors you got?
Can't show
Does he have? He's got quite a record. He's been in front of me a slew of times. Let me see him. Why does he keep coming back is the question.
Well, Judge, he has some issues. He has been doing better. He just purchased a home. He started a company. He's already got some clients for that.
Wow, this is hang on
He's
one second.
looking, I think, are you
What you reading, Judge?
trying to get into Taylor's sobriety court?
Into this one?
Into Taylor's.
Well,
Why into Taylor?
for wine.
I got into trouble the same week in Wyandotte, so I was trying to get the judge is there and everybody recommended me going to Taylor's sobriety court. He also recommended this one, but I didn't know if how the court would feel about me being here because of my one failure out of sobriety court.
Caitlin Foley, Karen, Professor Township.
I could be
Amanda, thank you
wrong.
very
It looks
much.
like he's got,
Just found his record page, the rap sheet. Got what?
oh boy. When did you get the one out of Taylor? This one got nolly-crossed out of this court. I don't know how.
He was 17 at the time. It was when the law changed for minors.
I see. And then he had the one out of this court from January of 22. Do you have any more prior convictions other than those two? I'm sorry, any prior conviction other than that one?
Just not with drinking.
I'm talking about drunk driving.
No, sir, just the.
Point is that, I don't know why they would have written that. This is a Wayne County sheriff. Lisa, can you find out where he's getting printed for that now? I don't know if he can go to a local police department. I think he can.
I have no idea. I'll have to make a phone call.
So I'm gonna enter an act guilty plea. I'm gonna give you $1,000 personal bond. I do want you going to AANA at least 3 times a week. We're gonna give you that form. Yeah, hang on.
I have my 90.
Hang on.
Sorry.
You have to go in person, and every time you go, you have to have the form signed. You cannot leave the state, cannot violate a law. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. I don't know what the BAC was here, do you?
As a .19.
So they could charge you with super drunk. You have to go over to get to the Wayne County Sheriff's Department. I think they're gonna have him printed somewhere local, Lisa. This was in,
Just have him stop and give me his phone number, and then I'll get a hold of him.
they didn't write this under MSEU, did they?
They did. Yeah, I texted the road patrol sergeant to see if their intention is to keep it with MESU or if they wanted to charge it with Wayne County with a warrant.
All right, we're gonna find out. You have to go get printed and photographed by 2 p.m. I'm gonna say by July the 17th. We're gonna give you a court date. They can figure out how they're going to proceed. Yeah, they can't just write that on there, and that's just not gonna work. So that's what we'll do. What's the court date for now, Lisa?
July 30th at 10:15.
Okay, July 30th at 10:15. Are you with me?
Yes, sir.
Okay, I wish you well.
All right, thank you, sir.
Fill out a petition for a court-appointed lawyer, get your order for bond. Listen to me. Where you going?
Oh, I thought you said I was.
Fill out your petition.
Where you
Get
go?
a court-appointed lawyer petition, fill it out.
Yes, sir.
Go down the hall, get your bond sheet, get your order for prints, and we'll make sure we give you an AA verification sheet, okay?
Yes, sir.
Good luck. Jonathan Ryan Cusin, 23B1444450.
Deanne Badillo on behalf of Mr. McCusin, state your full name for the court.
He's in front of Judge Hessen on violations. He's apparently, what are you, in mental health treatment court or substance abuse treatment court?
Well, actually, it was mental health, but it's been confirmed now that it's substance. Right, inpatient, outpatient treatment from the guidance center. 3 weeks a week would be.
I gotta keep your voice up.
It would be considered in treatment.
You're in
Judge, we
treatment,
were
but
here
you're
for
here.
sentencing. I'm not sure if this was adjourned because of Judge Hessen's violations or.
I didn't adjourn anything.
Because we were here for.
I said defendant to take care of warrants on June 3 and June 4, whatever that was adjourned for. I think I adjourned because he was inpatient, I think. Were you inpatient?
I was, but I didn't start the treatment sooner. I believe that's why I was trying to violate.
I'm not sure what that means.
So
Didn't start it
it's a
sooner.
drug paraphernalia charge. He's got violations in front of Judge Hessen. Has he gone in front of her yet?
No.
I see no reason to place him on probation. He's already on probation there.
Maybe that's something.
Anything you want to say, Counsel?
Yeah, Judge, he's halfway through his 12-step program. Like he said, he's in therapy 3 times a week at the Guidance Center. He's testing twice a week with 27th District Court. You're in there, Serenity Court, right? Yes, so Judge, he's already being monitored. He's gonna be monitored by 27. He's apparently being monitored by Judge Heston.
I'm not gonna place him on probation. Anything you want to say? Sir? 200 fines, 100 costs, 75 victims' rights fee, $50 justice assessment. 3 days on the court work program, $105 total for that.
3 days court work, wow.
Excuse me, 530, 3 days court work, or 90 days. Can you pay that now?
Not right now.
How much do you have today?
Couple weeks from now, you make a payment,
How much?
$50
Every week?
every other week.
Okay, fine, fair, $50 bi-weekly. I'll start that beginning on August the 1st. So August 1st, 15th, 29th, and then you're gonna go to September 12th, 26th, et cetera. If you don't have the money at any time, no problem, call the court, we'll go on Zoom, I'll be glad to give you an extension, okay? Just don't ignore me.
Tomorrow.
All right, thank you. People against?
Thank you, Judge.
Thank you.
Tomorrow,
Michael D. York.
BK hearing
24B146351A.
might be
Yeah,
lifted.
on behalf of Mr. York. Mr. York, if you can hear me.
We might get access to a lot of documents tomorrow. We're going to be following that one.
Hello,
Your name, Mr. York?
Michael David York.
All right, so he's in custody. He has been in custody since June 26th. Have you had a chance to review the report with him, and are there any material additions, corrections, or deletions?
We have reviewed the report. There are no additions, deletions, or corrections.
Anything you'd like to say in his behalf?
Yeah, he is, well, if he's released, he's possibly, and he's a member of the local 355 union in Bell Street. Prior to his incarceration, he was employed Eco-Built. He may be able to return to that, or he may be able to return to something else. He does have 2 children. He has attended a 12-step program, but the last time he attended that.
Is this the only case he's in custody on?
No. In custody for a case before Judge Heston.
What's that one?
Sir, anything you'd like to say?
No.
Judge, I would ask if you would consider treatment in lieu of jail. I see that the recommendation is for jail in the report. But he is trying to get his life together, and I think that he would benefit from treatment as opposed to jail.
Anything else, Mr. York?
No, sir.
100 fines, 200 costs, 75 victims' rights fee, $50 justice assessment, 4 1/4, 20 days jail credit, 20. You'll serve 70 more if you don't pay your fines and costs. I'm gonna let you pay those at the rate of $50 a week, beginning on August the 29th. August the 29th. If you don't have the money, you call the court, we'll go on Zoom, I'll be glad to give you an extension. Please don't ignore me, do you understand?
Yes, sir.
So I'm gonna let you out in terms of this case, but you still have to deal with Judge Heston. As long as you pay the 50 a week, I'll be happy to do that with you, but I'll be happy to, we'll be done with the case. There's no probation or anything else, but if you don't have the money, call the court. I'll give you an extension. Good luck. Kevin Michael Terry.
Thank you.
25B148684. Do you have a lawyer? Do you have a lawyer, sir?
I spoke with him.
Mr. Crawford, he was just in here.
I need Mr. Crawford. Can you get Mr. Crawford, ask him to come in real quick, please? Come on up here.
Judge, I just want to say you're the most fairest judge I've met in my life.
Okay, yeah,
He is.
you can, some will debate that with you. Mr. Adams will debate that with you. Well, sometimes.
Yeah. Helped out.
Depends how much I'm pushed.
Helped out.
All right, I'm gonna go ahead and dismiss this. They're saying plaintiff prosecutor moves to dismiss, co-defendants agree to a mutual dismissal. I gotta wait for your lawyer, if you'll just give me a second.
That's fine.
Yeah, that's good. Wait for the lawyer.
Do you guys have Mr. Crawford as your lawyer? Are you guys just watching? Who's your lawyer? Get Ms. Patillo in here, get Mr. Crawford, if he's, and we'll get them out of here.
What's time?
Let's recall Mr. Adams,
Judge
James
doesn't like
Robert
this
Adams,
courtroom.
Colin Caitlin Foley Carter.
What are you doing here?
25B823708.
We're watching for the
All
Shelby
right,
kneeling.
Mr. Adams, I'm gonna enter
sentencing
your
that should
name
start
again.
soon.
James Robert Adams.
I'm gonna enter a not guilty plea for you. You understand all your rights, correct?
Yes.
And you understand that if you committed a crime, you could get 90 days. And you also understand if this is deemed to be just a technical violation, you could only get 5, right?
Yes.
So you know all your rights, right?
Yes.
I'm entering a not guilty plea. When's the vet available?
Well, we're shooting for, based on your guys' calendars, Bobby won't be able to be here till, the second afternoon, so the day of the second in the afternoon.
Hang on.
Or the third. Anytime during the third, August 3rd.
Well, they gotta make sure I'm here.
That's a weekend.
Second is a Saturday. The Sunday's a,
We don't work Saturdays.
yeah, it's a Saturday.
I'm gonna go grab it there here.
Yeah.
And then the third's a Sunday.
It was that, just got on his calendar. It's that Wednesday in August. Can I call him?
But you're bringing your vet though, right? That's what I want to hear from.
I'm gonna, yes.
August what?
This is the dog dude again, right?
So what is the third?
That's a Monday.
Move out of the way.
August 4th is a Monday. And I'm gonna
Yeah.
dock it in the afternoon.
What about the, what is good for that week? Because he gets back that week.
I'll do the 4th.
Okay.
Can we do it in the morning?
I don't care. Lisa, so I'm gonna set it for August
Gonna shrink
4th
a
at
little
what
bit.
time? You think I can do? Could we do it at 8? You want to do it at 8:30?
You have landlord tenant that morning.
I know.
That help.
We'll do it at 8:30. August 4th at 8:30. And they'll just have to, yeah. But tell your lawyer or your vet, I need them here at 8:30 because I'm gonna start at 8:30, okay?
Okay.
All right, personal bond.
Tell your lawyer or your vet.
Good luck. Notice down the hall. Thank you. Kevin Michael Terry, 25B148684. This case is going to, Mr. Crawford, your name?
Your Honor, Michael Crawford, representing Mr. Terry.
Your name, sir?
Kevin Michael Terry.
Prosecutor moves to dismiss, says co-defendants agree to a mutual dismissal. Case dismissed.
Thank you, Your Honor.
Do I have any other files? Do you have any others?
You're done.
Stay safe.
Good luck. You too. Thank you.
Case dismissed.
Do you have a case? Do you have a case in here?
Yes, I do.
Tomorrow, Judge.
Oh, it's tomorrow.
The judge would move. I'd take his chair.
Discuss the strategy for our.
You go talk to my judicial
He
clerk.
gave him all the information already.
Okay. Brandon Wright, Brandon Edward Wright, 25B148693. Does he stand mute? Counsel, your appearance?
Michael Crawford, representing.
Stands mute, waits for my reading?
Yes, Your Honor.
Not guilty, please entered.
No, Your Honor.
Your name? Now they're moving to dismiss. Mutual combatants, right?
Yes, Your Honor.
Case dismissed,
Mutual
motion to the
combat.
prosecutor. Good luck.
We agreed to
So go
fight.
talk to her.
Case
She'll-
dismissed.
She'll tell you what to do unless she already has. Okay?
Thank you.
Good luck. What else do I have?
We have an outro.
your no-shows.
We'll do them after lunch.
Okay, let me see if I
All
can
right,
take the
Mr.
judges.
Gabrielle, we'll see you tomorrow. If you're in front of me, you in front of me? Yeah, I'll see you
Oh, this
tomorrow.
chair is nice.
Okay.
Oh, yeah. Yeah, this is good. Need to be a little bigger, though.
Yeah.
Let's see, put me right there. Is that? There we go. That's still a tiny bit too big. Let's be right here. Boom. All right. Now listen up. Listen up. I'm not a judge. Oh, bailiff's here. I need to go. Need to go.
John, was that it, or did Miss Patia have more?
Oh, I don't know. I'm gonna look.
Everyone just runs out. I don't know what's going on.
I just got back
I'm
here.
here. I'm sorry, what did you say?
Is there more? Or are we done?
I have 2 more.
I don't know if Judge realizes that. I'm going to call him.
Okay, just 2 more. All right.
Okay, sorry.
That's okay.
Judge has already got the robe off. He's got the order placed for lunch. He's halfway through a meatball sub sandwich from Subway, courtesy of that other witness, another defendant.
Judge. Don't leave it.
Judge. What? What? All right. Mod chat. Thank you. We're looking for Shelby Neely right now to see if we can get the clean feed on that. O.J. Simpson estate hearing. Josh has one. Civil. Let me look at this. Josh found this little civil case that involves a scammer, which you know I'm partial to. Let's see what we can find here. Wait for it. Judge Scott McAfee. There he is. Let's see what we got. Let's take a quick peek and see if this is worth watching during our break while we wait for a bigger trial. Opening statement by the plaintiff. This is civil, so we have not watched a civil trial, like a good one, in a while.
Evidence, but it's going to basically hear testimony and see documentary evidence, but it's going to basically tell a story. We believe that the evidence is going to show that Mr. Ray is a small businessman who is mistreated by a scammer. Who had his money stolen from him. And then just as the business was about to turn the corner and become profitable, he was fired. And that this business was a Chevron, was a gas station, convenience store. You've gathered that, I'm sure, as part of the voir dire process. What you don't know is that the evidence is going to show that these were business partners that joined together to operate this convenience store. And that there was problems with the operations. You're going to hear all about those problems. The evidence is going to show that there's only one solution, and that is to unwind the deal. The evidence is going to show that Mr. Ray is entitled to an award from the jury,
statement.
$384,904.79, which is the money that he is paid to the three defendants.
384,000.
We are asking you to unwind that deal. Now,
back it up.
I want to introduce you to the parties in this case. First of all, we have the plaintiff, Dinesh
Get out of the
Ray.
way.
I'm going to call him mostly either Dinesh or Mr. Ray, but Dinesh is the plaintiff. He is a gentleman who has tremendous experience running convenience stores.
Okay.
Mr. Ray is a purchaser / investor of the Chevron gas station and convenience store. This is the story about Mr. Ray bringing in his experience as a manager, operator, and even a previous owner of a convenience store, combining with Mr. Khan, who was the owner and operator of defendant in Nahar Investments. And together, the two of them were going to come and run this convenience store.
We'll get full screen.
Mr. Ray believed that because he has tremendous experience in the convenience store business, that he was a natural partner to someone who wanted to invest in convenience stores, but did not necessarily want to operate them. If you want someone who knows and understands the convenience store business, Mr. Ray said, I'm the guy. I've done it. It's in my family. I am the guy to run this business. Because of his expertise, Mr. Ray believed he could run the store, he could manage the coin-operated amusement machines or COAM machines, that he had the experience to order the merchandise, to manage the gas supplies, and to be the operations guy of the partnership. Dinesh rightfully believed that he was a perfect person to run this business. And the evidence is going to show that Mr. Khan, the defendant, recognized this fact. Dinesh believed that he would be treated fairly by Mr. Khan. However, the evidence is going to show that is not the case. The evidence is going to show that this business was having problems from the beginning.
This is a civil
and that the
jury
problems
trial.
only got worse before they could ever get better. Dinesh did not have a fair chance to run this business given the problems that he had. But Dinesh did not know these problems were even coming on the horizon when he did this deal. He agreed to purchase 49% of the Chevron gas station and convenience store. And of course, 51% would be owned by Mr. Khan still. So think of In Nahar Investments. That is the company that owns the gas station. Mr. Khan owned 100% of In Nahar Investments. Now, just to make this easier, I'm just going to refer to it Nahar. Nahar is a company. So think about Mr. Khan, 100% owner of Nahar. Nahar, 100% owner of the Chevron gas station. So even though we may be saying sometimes Nahar, sometimes I may say the convenience store, sometimes I may say the Chevron, really we're talking about the same thing. The business is the operation of the Chevron gas station and convenience store. The 49% was what Mr. Ray was purchasing. So he was going to become a not quite equal partner. Mr. Khan was going to retain 51% and thus would retain control.
Not quite equal.
The evidence is going to show that Mr. Ray paid $347,733.26 to the defendants. The evidence is going to show that these were a variety of payments. Some went to Mr. Khan, some went to Nahar, and some went to TSTT, the third defendant.
Okay.
Now, the evidence is going to show that they did this deal. Then Mr. Ray went and started operating the business. He was the operations guy, after all. He was a guy who had the experience, and he was a guy who was going to be the store manager, or order the merchandise, and use his experience to build and grow the business. Now, the evidence is going to show that Dinesh was fired during a difficult time. And we'll talk at length about what those difficult times were and what Mr. Ray was doing to try to recover from those difficult times. However, just as the business was about to turn the corner, that's when Dinesh was fired. So he was not allowed to see the success that he had worked hard to build. He was not allowed to participate in the financial windfall of the revived business. Now, you're going to hear about the investments that Dinesh made. I already said He paid $347,000 to buy this 49% interest in the business. However, he didn't get any stock certificates. He did not get any membership shares. He never got to see bank accounts. He never got any tax documents. So when the company had a loss, he did not participate in the loss. He wasn't able to deduct that loss on his taxes. When the company had a profit, he did not get a profit share. He never got a single K-1 document. The evidence going to show he got nothing for the money that he paid.
Not a zip.
Now let's meet the defendants. We have Mr. Khan, who is here with us today.
I need pictures.
And he had 100% of the shares of Nahar.
We're going to see
So
Mr.
the
Khan
contracts are going
eventually.
to be sort of complicated because you got the three parties. You got Mr. Khan, Dinesh, and Nahar are all sort of intertwined in these documents. When the witnesses take the witness stand, we will ask them to explain to you what the documents show. The documents will hopefully be admitted into evidence, and that will be a part of the overall case. However, the documents don't tell the whole story because the documents do not show what happened afterwards. Does not show the intent of Mr. Khan when the documents were signed. So Nahar is a limited liability company that owns the Chevron business. And Dinesh bought 49% of Nahar. Now, the payments that he made were to Nahar. The payments that he made, some of them, was to TSTT, which is another defendant. So let's talk about the business itself. So the business is your typical Chevron gas station and convenience store. The business is located at 1131 North Hairston Road, Stone Mountain, Georgia 30083. Dinesh was to be the store manager, the operator of the business, and to run the day-to-day operations, order supplies, hire staff, schedule staff, do all the things that a store manager would be expected to do.
Good picture.
Now, as an owner, Mr. Ray expected to participate in the profits that he generated. But even if he didn't generate profits, he should at least participate in the losses that the business generated. I think the evidence will show that there were some good times and some bad times. Now, Dinesh did not receive any ownership rights or stock certificates or shares or anything like that, like we've talked about. And the evidence is going to show that Mr. Khan took the money and gave Mr. Ray nothing. So starting in October 2021, the parties were talking about collaborating on a business. The evidence is going to show that at the time where they started talking about it, Mr. Ray owned his own convenience store. Mr. Khan owned one or more convenience stores himself. That in fact, the Chevron was very close to Mr. Ray's own business. But because of a lease dispute with his landlord, he ended up closing that business. That made him available to do a deal with Mr. Khan. The evidence is going to show that they basically came together as partners. We have Dinesh, who is the operations guy, and Mr. Khan, who's the money guy. You will learn that Mr. Khan controlled the process. He had his attorney draft the documents. He did not really negotiate with Mr. Ray, did not give Mr. Ray a chance to see the contracts until they all showed up for signature at the attorney's office for closing. In fact, the evidence is going to show that Mr. Ray paid $200,000 as part of the closing, earnest money, and cash due at closing, without really knowing the full details of what he was getting himself into.
Have you filled up at this Chevron?
After closing, Dinesh started work. He assumed Mr. Khan was going to be an honorable guy, that he was going to do what they agreed. 51%, 49%, that they were going to be business partners. And if Dinesh worked hard and ran the store the way that he knew he could and be profitable in a way that his experience told him he could, that there would be plenty of money for both of them. Unfortunately, problems arose fairly quickly. It became apparent that the business had issues, that there were some financial issues, that no matter how many times he asked, Dinesh was not given access to the online bank accounts. Dinesh was not given an opportunity to talk to any financial advisors, any accountants, or any bookkeepers for the business. Dinesh had no idea how the business was performing. The evidence is going to show that as early as the closing, that Mr. Khan knew that he needed to open a bank account that Dinesh was on, to give Dinesh access to the bank accounts, to give Dinesh involvement as a partner in the business. Despite that knowledge, in February of 2022, Mr. Khan did not ever add Dinesh to the bank account. He did not ever open another bank account that was jointly titled. The evidence is going to show that these contracts were terribly one-sided, that they required Dinesh to pay a guaranteed profit. I'm going to use that in air quotes because that's what the contract called it, a guaranteed profit of $5,000 a month. Dinesh also had to pay another payment of $5,344 a month. So before there was any profit for the business at all, there was $10,000 in overhead, in addition to having to buy the gas and the merchandise and all the items to go in the store.
He had to buy that himself?
The evidence is going to show that there were issues with the business and the coin-operated amusement machines, the COAM. We're going to talk at length about COAM when Dinesh takes a witness stand and explains to you what it is, how it operates, and how that impacted the business. Because the defendant did not accurately explain what the profits, loss, revenue of the business were, Dinesh really did not know that there were hidden issues. The evidence is going to show that there was not any due diligence provided, no documents provided to Dinesh regarding previous financial performance of the business. Dinesh remembers an operations guy, so he was more focused on the lease, the COAM contract, supplies, merchandise. He assumed that if he did his job, that he would the finances would take care of themselves. It was not until his repeated requests to be given access to financial information were denied or ignored. That's when it became more and more obvious that there were probably financial issues going on here. Now, Dinesh operated the business diligently, but this could not be sustained because of the issues with the COAM business. Shortly after they started working, the COAM license was suspended. And as a result of that suspension, they lost the license for 12 months. That's when the financial troubles really hit. The parties agreed to suspend the regular payments, and they toughed it out. Dinesh actually worked shifts. He was not only a manager, but he was working shifts at the store. And he was doing everything he could to keep the store alive. The evidence is going to show right before the suspension of the COAM license ended, right before COAM machines, the machines would go back online, that's when he was fired. And it was because of the fact that the COAM machines were about to go online, that's why he was fired. He was not given the opportunity to reap the reward of the 12-month suspension, the hard times that he suffered through. He was not allowed to reap the rewards of when that hard times would come to an end.
They had a 12-month suspension.
The evidence is going to show
illegal
that
gambling.
Mr. Khan kept that money for himself. That Mr. Khan fired Dinesh from the business and since then has basically ignored Mr. Red. Now, as a true owner, Dinesh should have received 49% of the profits. He should have received a K-1 for his taxes. The evidence is going to show he got nothing. And that's where the problem is. When Mr. Ray was fired, he had paid a total of $347,733.26 to the defendants. And he also paid money to the vendors out of his pocket. The evidence is going to show he paid almost $16,000 out of his pocket. So let's talk about the payments from Dinesh.
Oh,
so
we have receipts.
First of all, we have the total amount that was paid, which is $347,733.26. So let's show how this money was paid. First of all, we have the first $50,000. Those are the two earnest money checks of $25,000 each. Those checks are written on the name of Bell's Food Mart. Now, Bell's Food Mart is the company that Mr. Ray operated before he went into partnership with Mr. Khan. So you're going to see when we introduce the checks as evidence, you're going to see that they're written on an account called Bell's Food Mart, but they are signed by Mr. Ray. Those checks will go towards the closing. Then after those checks, you're going to see the 3 checks for the money due at closing. These 3 checks total $150,000. Remember, I mentioned earlier, he was 200 grand in at closing. So that is $200,000, 50 earnest money, 150 paid at closing. The evidence is going to show all those other checks are payments that Dinesh made to one or more of the defendants. And that totals $131,750. And that are the checks that were paid over time and checks that were paid to the different, in the hard investments. Those payments were in addition to the $200,000 paid at closing. Now, the evidence, when Mr. Ray takes the witness stand, he'll explain to you what all these checks are for and who they went to and why they were written the way that they were written. Suffice to say, for purposes of this conversation, this is a total of payments made to the defendants. So let's go to
the last
final
one.
Page.
85,000.
In summary, we're asking you to award total damages of $384,904.79. So that's composed of unwinding the deal, which is the payments that were made, $347,733.26. Those are all the payments that Mr. Ray made to the defendants and the payments he wrote, the checks he wrote directly to vendors out of his own pocket. So we're asking for that. Plus, we're asking for attorney's fees of $37,171.53. So the total that we're seeking today is $384,904.79. But you remember how I told you Mr. Khan was a scammer. The evidence is going to show that his actions amounted to fraud. And if you find that his actions did amount to fraud, or that he converted the funds that were entrusted to him by Mr. Ray to his own personal use, then in that case, we're going to come back to you and ask you to make an award of punitive damages.
Oh, that's.
Let me thank you again for your service today and for the help that you're going to give to Mr. Ray to get his justice. Thank you.
And the lawyers get 30% of the punitive damages, I'm guessing.
Okay, go ahead and log out.
Good afternoon.
Okay, log
Like
out.
Mr. Collins said, appreciate your time.
Cancel, don't save.
My client, Mr. Khan, on behalf of himself individually and his companies, he's also, very appreciative of the fact that despite everybody's
we get a video.
he also gets his day. You heard Mr. Collins refer to my client as a scam multiple times. This is going to show
Get a
that
new
nothing could be
PowerPoint.
further from the truth. In fact, the evidence is going to show that my client did everything he could to allow Mr. Ray to fulfill the obligations that he agreed to in his contracts. And Mr. Ray was so unsuccessful in fulfilling those obligations, my client had to pay exorbitant amounts of money that were responsible by Mr. Ray in those contracts just to try to keep the business afloat. Slide. As Mr. Collins referred to, at the time of the facts in question,
better pictures.
These individuals were dealing with this Chevron gas station business. As Mr. Collins referenced, the arrangement of being a potential partner was such that Mr. Ray, who, as Mr. Collins stated, had all of this experience in the gas station and convenience store business, approached my client to be a partner for this particular station. Now,
We're sliding literally from slide to slide.
the good news for you is that you're not going to have to worry about what somebody thinks the deal was, what their impression was, what they think was supposed to happen, but it didn't, because it's all written down in a contract. You're going to see two contracts. One is going to be for the purchase of 49% of my client's business and our LLC. And you are going to see that on February 11th, 2022, my client did in fact agree to allow Mr. Ray to purchase 49% of that company. You're also going to see that simultaneously, because there was going to be this 51%, 49% partnership, that the partners entered into an operating agreement. Now, what you are also going to see is that as part of both that purchase agreement and the operating agreement, Mr. Ray, who admittedly from his own attorney has so much experience and expertise in the gas station and convenience store business, decided to agree to the following. The documents are going to show, number one, that during the time that he is to manage the business, he is responsible for making sure that all of the business overhead is taken care of. You're also going to see that he agreed that in addition to ensuring that all of those bills are paid, that $5,000 a month was paid to his partner, Mr. Khan. You're also going to see in both of those contracts that he agreed to indemnify and hold harmless Mr. Khan even beyond the management period for any claims and losses and liabilities relating to the lease with the landlord, the fuel supply contract with Chevron, and with the coin-operated amusement machine agreement. You're also going to see that the contract clearly states that in the event Mr. Ray failed to meet those obligations for that management period time, that Mr. Khan had the right to expel him as a manager and reclaim the management position for himself. Now, you are going to see that both of these contracts specifically say the initial management period was going to run from February 11th, 2022 until January 31st, 2024. As I've already alluded to, the contracts are going to say that Mr. Khan had a right to shorten that management period time in the event that Mr. Ray failed to meet his contractual obligations. Now, that contract also states that in the event that the business had any net profit beyond those bills being paid and the $5,000 being paid to Mr. Khan every month, Mr. Ray would keep all of the rest of the net profits. Now, you are going to see from the evidence that neither Mr. Khan nor Nahar LLC breached any of the agreements. You're also going to see that there was no fraud that was committed on the part of Mr. Khan or Nahar LLC. In fact, you are going to see multiple references within these contracts to the fact that the parties are not relying on any promises, guarantees, or anything of the like other than what is in that contract. Slide. We've already gone over the principal terms that Mr. Ray agreed to under these contracts. These bullet points reiterate those principal terms. Now, I want to be clear. Not only did Mr. Khan agree to allow Mr. Ray to be the manager and collect all the net profits after those liabilities were covered, the purchase price to own 49% of this company was $263,170. He still hasn't paid that. He's only paid a fraction of that. So there is a deficiency not only with the purchase price, but there is a large deficiency in all of the bills and overhead expenses that Mr. Ray was responsible for that my client ended up having to pay. Furthermore, you're going to see that there is a deficiency with respect to the $5,000 monthly payments that Mr. Ray was to make to Mr. Khan. And you are going to see plainly spelled out in the contract that at the end of the management period, whether it be the entire period, again, January 31st, 2024, or any time beforehand, which in this case, it was cut short prematurely to November 11, 2023, that the inventory shortfall for the store would be the responsibility of Mr. Ray. Conversely, if the inventory was higher than what it was when the management period began, he would be owed this. So you're going to see a deficiency on the purchase price, the bills that he was responsible for paying that my client ended up paying, the $5,000 monthly payments, and the inventory shortfall. Slide.
We followed the full case.
As I alluded to
through
earlier,
case.
there is nothing that transpired between these individuals that was fraudulent. Just as my client had every opportunity to contemplate and explore the notion of selling 49% of his company to Mr. Ray, Mr. Ray likewise had every opportunity, again, as an expert in the gas station and convenience store industry, having all this experience, in fact, having a gas station across the street from the Chevron at issue, had every opportunity to demand any additional due diligence time in the agreement, to consult with as many lawyers as he wanted to before he entered into the agreement. And there is nothing that transpired after that or before that could possibly be construed as a fraud. When we were doing our voir dire, several of the prospective jurors mentioned that they had attempted various business ventures, and all but one has been unsuccessful. We all know that entering into a business can be a risky proposition. Sometimes we win, sometimes we lose. And in this case, the reality is he agreed to what he agreed to. The contracts speak for themselves. If the business wasn't profitable, it's not only not profitable for Mr. Ray, it's not profitable for Mr. Khan. And the evidence is going to show that this entire notion that Mr. Ray was let go as a manager, just as the business was about to turn around, well, this business has operated at a net loss since February 11, 2022. So like I said, the evidence is going to show that not only did Mr. Khan pay exorbitant amounts of money that was the responsibility of Mr. Ray under the company just to keep the business afloat, it is still to this day barely hanging on. So if there's anybody that went above and beyond to ensure that this business would be a successful venture, it sure wasn't Mr. Ray, it was Mr. Khan. And like I said before, the notion of Mr. Ray being expelled as a manager is clearly within Mr. Khan's rights as outlined in the contract. Slide. Like I said before,
why the plaintiff
Mr.
is
Ray
wrong.
freely entered into the agreements, and you've heard his attorney talk about how much experience he has in the gas station and convenience store industry. So he knew full well what his opportunity, risks, and benefits were.
I'm going to try to skip ahead through this.
The obligations of Mr. Ray could not be more clearly defined in both the purchase agreement for the 49% and the operating agreement between the partners. You are going to see, without question, that Mr. Ray did not comply with those obligations. Yes, the business was not successful. The business was losing money. But that does not change the fact that the evidence is going to show that it was his responsibility, if he wanted to have that management position and potentially reap all of that net profit after that overhead was taken care of, to be responsible for those bills. As I continue to state, and as you're going to hear at the conclusion of this trial, my client and Nahar did not commit any fraudulent activity. Everybody went into this deal eyes wide open, and everybody knew what was happening with the business. Nobody better than Mr. Ray, because he was the one in the store managing it every day. So this entire notion that he was in the dark on the finances is a paradox. He was the manager between February 11th, 2022 and November 11th, 2023. As Mr. Collins correctly noted, my client wasn't running the store. So it's a paradox again to say that he was in the dark about the finances of the company when he's running the company every day. Now, this is something I want to hammer home. There have been, as you can imagine, various documents, statements, responses that we have gathered throughout the course of this case from Mr. Ray. And the evidence is going to show that these claims are inconsistent, they're incompatible. The statements are contradictory and inconsistent. And at best, going into this trial, one could only assume that he just thinks he should get his money back. That's it. A business went bad, he's upset about it, and he wants his money back. Well, my client wants his money back too. Money that he agreed to pay. Now, you heard Mr. Collins say in his opening that conclusively, what he wants is to unwind the deal. Because the business operations were so poor, the only thing that is suitable is to unwind the deal. And therefore, everything that he paid should just go back to him. Well, you are going to see multiple claims and statements and positions asserted by the plaintiff that completely contradict that that's what he wants. Sorry. Now,
what are you guys asking
he is claiming that what he wants is to undo the deal, to rescind the deal, to go back to where the parties were before February 11th, 2022. Please, number one, listen closely to what the documents and the witnesses say. Please pay particular attention to the timeline of events that transpired between February 11th, 2022 and November 11th, 2023, which is when the management period was cut short, to what you are going to see for the first time ever, a demand from Mr. Ray in May of 2024, all the way to the lawsuit that was filed in June of last year. And then try to comprehend the notion of, quote, unwinding the deal. Now, as the judge pointed out as part of his introductory remarks, I would also like you to just please bear in mind, yes, Mr. Ray, in the style of this case, is denoted as the plaintiff. As you will see, in his lawsuit, he claimed 3 substantive causes of action: breach of contract, fraud, and conversion. Please bear in mind that it's carrying that burden of proof for those causes of action. And that for my clients, Muhammad Khan and Endahar Investment, for its one and only substantive counterclaim, which is breach of contract, breaching the purchase agreement, breaching the operating agreement, we carry that burden for the damages that we're seeking in regard to that counterclaim. Now, I also, again, I said I was going to hammer it home, and I am. Although his lawsuit has 3 substantive claims, breach of contract, fraud, and conversion, you heard Mr. Collins in his opening say what they're asking for is to unwind the deal, put the parties back to where they were in the beginning, to rescind that deal. Please, at the conclusion of the closing arguments between counsel, pay careful attention to the judge's instructions on what the law is for those claims. And after you go back and deliberate, this is what we're asking you to conclude. We're asking you to reach a verdict in favor of the defendants as to plaintiff's claims: breach of contract, fraud, and conversion. Obviously, when that occurs, those ancillary claims for legal fees and punitive damages will necessarily die off. However, as to our counterclaim, we are going to show you simply based on the purchase agreement and the operating agreement that a principal amount of $338,378.85 is still owed to Mr. Khan and Endahar LLC. We know this because $5,000 was short for cash at the closing. We also know that part of this purchase price, if you'll recall, was $263,107. was part of a promissory note. The promissory note was $63,107. That remains totally delinquent, despite the fact that he had been managing the store for over a year. You're going to see that for the 21 months that Mr. Ray was a manager, where he owed Mr. Khan $5,000 a month, he's short $80,000. And you're also going to see that all of the liabilities, all of the overhead costs, all of the bills, fines, anything that is specified in the purchase agreement and operating agreement in terms of liabilities that Mr. Ray is responsible for, there is a total of $128,292.50 that my clients ended up having to pay because he didn't. And it was the only way to keep that business running. And as I mentioned earlier, when the plaintiff was expelled as a manager of the company, there was an inventory shortfall of $61,979.35. At no time has my client ever asserted or took the position that Mr. Ray does not own 49% of that company. You're never going to see a piece of paper representing that. In fact, you're only going to see and hear testimony that shows he is a 49% owner. The problem is, as I mentioned earlier, you're going to hear testimony that plainly establishes that owning 49% of Nahar LLC since 2022 means you own 49% of a negative number. So all of this insinuation that there's this jackpot of money that somehow Mr. Ray is supposed to be owed because he is a 49% owner of the company is just smoke and mirrors. There's nothing out there that represents this small fortune waiting in the wings. As I mentioned earlier, we know from February 22 to November 2023 who was running the business. And we know that the business, by Mr. Collins' own admission in his opening, was not making any money. So there's no money to be had there. And between November 11, 2023, all through the taxable year of 2024, there's not going to be any pot of gold there either. So basically what you are going to be left with is a case where Mr. Ray had the temerity, knowing that he failed to fulfill all of these plainly spelled out conditions in contracts that he, as an expert in the gas station and convenience store industry, agreed to sign. He failed to pay my clients all of this money, and yet has the audacity to say, well, not only is this irrelevant, I should get all the money back that I paid for this business as well. And mind you, when the slide was up during the plaintiff's opening, and there were two columns, one of those columns was literally bills that were paid by Mr. Ray during the management period. Well, I can't emphasize this enough. Both the purchase agreement and operating agreement say, when you are the manager, you have to pay all of the bills. You get any net profit after all of the bills are paid, and $5,000 a month is paid to Mr. Khan. So it's even more audacious to claim that he should be getting back the money that he put into the business that the contracts specifically say he's supposed to put into the business. Now, lastly, we too have an ancillary counterclaim for attorney's fees and litigation expenses.
But we're much more expensive.
We believe that the evidence is going to clearly establish that the fact we had to defend this lawsuit and actually go to court for that sum of money could not more clearly represent a stubbornness, an appetite for litigiousness that would, and just complete undue trouble and unnecessary expense for Mr. Khan and Nahar, that you should come back from that deliberation and award our attorney fees and litigation expenses associated with having to deal with this case. Now, as of this morning, the sum that we were seeking was roughly $9,000 less than plaintiff's counsel. It was about $27,500. Now, obviously, you see attorneys here at the table. We're here for this trial. And when we do our closing, we will have that final number for your review when we necessarily have to tack on the legal fees and the court costs associated with defending this action as part of this trial. So I just want to make clear that you're really not going to have to worry too much about what anybody says happened, what they think was supposed to happen, what they were hoping was going to happen. And the judge mentioned in his opening remarks, it's a contract case. And the good news is you're going to have the contract. You can literally see without any confusion what Mr. Ray agreed to do. And after hearing from Mr. Khan, you're going to be able to clearly outline all of the monies that he still owes. Again, I thank you for your patience. I thank you for your time. And again, we all know how busy everybody's schedule is, but we're glad that we have this opportunity to finally put some closure on this case. Thank you.
All right. And so opening statements having concluded, members of the jury, we would now begin with the plaintiff's opportunity to present evidence.
All right. But instead, we're going to go straight to our verdict, which hasn't come in yet. We are going to we're going to just go to our poll. I can't listen to this. First of all, let me tell you what I think about this case. Josh, it was fun to listen to the openings and to see the competing PowerPoints. I personally have decided the second PowerPoint was better, but the presentation was worse. So I'm not sure where that leaves us. Probably still neck and neck as far as the two sides go. People. Read the dang contract before you sign it. If there's a legal agreement out there that says we're going to be partners and you provide all the profit guaranteed to the other side every month, and you pay for all the operating expenses, and if there's any extra, you get to keep that, it's a bad contract. I don't know how this will end, but I think the way it should end is Mr. Ray. I'm sorry, Mr. Ray. You lose. I don't know if the contract says you need to pay more, but you lose. You signed a bad contract. Asking it to be unwound because the company lost money does not work. That was bad. That was lay bad contract. Don't want to run a gas station anymore. I'm striking that off my bucket list. Apparently, the contract part is just going to kill me. So, all right. It's 12:51. We're going to take a little lunch break, and when we come back, we're going to possibly talk a little bit about Brian Kober, who's coming up tomorrow. That's a hearing we're going to follow. That's going to happen about midday. This is a gag order hearing where the two sides might be released from the gag order, so they might be able to talk to the public. They may also unseal all the documents that have been sealed thus far in the case. Now, realize that it seems like they shouldn't need to be sealed anymore because he pled guilty. We still have sentencing that's going to happen on, I believe, the 23rd? That's going to be a week from today. We're going to cover that. I'll cover that from Bear Lake, Idaho. I'll be set up live on vacation covering that hearing. So I will be in Idaho to cover Brian Kober. I'm just going to be a few hours away from the actual hearing. But that's going to happen if I've got my dates right then. If you can't profit running a business that sells gas, stop buying things. Oh, we've got a scam call. Hang on. Hello?
Hello.
Hello.
Hi, sir. My name is Miles. How are you?
I'm doing away. Okay.
Great. Sir, actually, I was just scrolling through the feed and just got your number from the online databases that you have shown some interest in the real estate in the past. I was just calling to see if you're still interested in buying or selling any property.
I am very interested in buying property.
Okay. What sort of a property are you looking for?
Real estate. I've got my fingers in a couple pie. I'd like to have some coin operated laundry. If you've got any commercial stuff, obviously car washes, I'm into that. I'd like to build my portfolio when it comes to mini storage, but also rentals. I don't have a problem with being a slumlord. So if you've got some properties out there that are, multifamily units, low regulation where I can raise the rent, things like that, and just make a killing, sign me up for that. Just basically anything. Hello? He hung up on me. He hung up. I'm your guy. Call me back. Call me back. Oh man. I guess he's not selling slumlord properties. Too good to be true. Man. How do you I'm trying to get into one of these really bad contracts with somebody, but they hang up. They hang up so quick. Maybe he was wanting me to sell. Oh, that's it. He probably wanted me to sell my property. He thought I was Dwayne. He's like, no, Dwayne's got this. He's got the squatter. He's got the squatter situation in the old meth house. He can't be buying. You were way too keen. So you want the video rent? Oh, if I can get into that one of those blockbuster franchises, one of those sweet blockbuster franchises, those are just money. Of all the times to be talking contracts, Ivan, I apologize. I realize you're going through a difficult time with the business and all. It's hard to convince all the other people to pay a fair wage. No, I don't know where you stand on that. I know you're hiring at $25 an hour or something, which is good money. Good money. So should have said you wanted 49% of a gas station. Do you have any chevrons available? I'm interested in a chevron. Why did he hang up? Maybe I talked too fast and he just couldn't understand me. I should have been a little more simple and let him sort of lead the conversation. Okay, I learn a little bit. I learn. Josh says, have a good rest of the day, y'all. I'm going to watch the rest of the trial because I'm invested. I've ordered my chevron hat and jacket, and I'm going to watch the end of the civil trial. Sounds good. You said slumlord and he clicked off. That might have been it. I'd like to run an internet cafe. I don't know. This is not a scam call. Sorry.
Hello.
Hello. Sorry, that was my renter again saying, did you steal my package? We didn't. Her phone got delivered, but to the back door instead of the front door. She came to the front door and it wasn't here. All right. What's up? Where's RA? I'm back, but we're going to go. She has her phone. She's happy now. Thanks, Logan. Hope everything's good. Thanks for watching. All right. Used to have a paper out. That's good money. No, it's just a lot of work. It's terrible money. Second time today, he's giving us the finger. Okay, I just ran. Now I need to go potty. All right. We're going to go to break. We're going to go to break because we're going to go to lunch. When we come back, we're going to keep doing a little bit. Not this trial. Sorry, the civil trial. I'm nixing it. Let me also, so let's unpin that. Let me end the poll. It looks like as far as this civil suit, we have the poll is complete. Judge throws them all out, 41%. Mr. Wright gets his money back, 31%, and defendants get paid additional money, 26%. So I think the judge is going to be like, bad contract. You guys get nothing. All right. Whew. I just ran just a little bit. I think this is all. I think that's it. All right. We're going to go to lunch. If you come back, Josh, you're terrible. You're terrible. Yeah, the civil trial, I nixed it. It's basically, it would be like rewatching the Murdaugh trial, but without any of the murder parts. It would just be the financial details. And not just financial details, just like reading the check balances and dates. That's all it's going to be. It's going to be terrible. I'll portal us over to the new one. How about that? Let me schedule a stream for. You know, if I build a portal and send you over to it, you know what's going to happen. What time is it now? It's 1 o'clock. We're going to give an hour lunch. We'll be back at 2. Okay, it's created. Making the portal as we speak. Nobody's in there yet. Redirect to that one. Save. And let's see who's first. It was Britta. Britta, congratulations. Pin the message. Heather from Texas came in a close second. All right, tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe till we go live. Soon. You know what I can do? What's really cool? I just figured I could do this. Hang on 1 second. Wait for it. Reset. Sorry, missed it. That's huge. Holy cow! Can I just be one size? There, I'm big. I can be in both places. That's cool. The green screen is a little bit fuzzy over the shoulder. All right, we're going to lunch. You guys get some food. We're going to be back. We're going to have some fun, and I'm going to disappear. And you can see just the thing when I'm gone.